Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. First case for argument is People v. Pulley. Case number 361, Robert Pulley.
Morning, Your Honors. David Abbatory for Robert Pulley. I'd like to focus my attention this morning really on the first 2 points in my brief and maybe leave a little bit of time to talk about my Batson and 71030 points. Starting out with the weight of the evidence issue, I don't intend to argue the facts of the case. I know the court is aware of these things. But I did want to touch on one legal issue that arises out of our weight point, which is kind of a threshold determination that this court has to make with respect to whether or not Dyson's testimony is incredible as a matter of law. That does, in fact, present a legal question for this court. I think the prosecutor has tried to frame this as just one other element of deference that this court could use to resolve that question. But the case law on this subject says that if Dyson's testimony is incredible as a matter of law, that it should be disregarded as being without any evidentiary value.
And the basis for that, counsel, is that it's incredible in your mind because it's so different from what he initially reported shortly after the incident.
Yeah, I think yes, and that's just one element of our incredibility argument. I think.
But you say it also seems to be unbelievable that the shooter would stop in front of him as he's traveling down the roadway. Those type of things. We're supposed to draw some inferences that just doesn't make sense.
And that's another element of it. But I think even if you accept Dyson's testimony kind of as he gives it at the trial, and forget about the fact that he's drastically changed his story. His first story makes a lot of sense. I saw this shooting happened. My girlfriend told me to keep driving, so I just kept driving. His second story doesn't really make any sense. But even if you kind of accept that that is what happened that day, it doesn't make any sense, and it does not comport with human experience.
How long after this crime did he actually ID him in a photo array?
I believe it's 11 years.
11 years. Did he know this gentleman beforehand?
No, he's a total stranger.
Total stranger. He did pick him out of a lineup, or I'm sorry, not a lineup, but a photo array. At the time, because I know this is an old case, I believe it's an old case, was it admissible? Somebody identifying someone in a photo array. You know, the law changed. It used to be not admissible. Now it is.
Yeah.
Was it admissible at this trial that he pulled him out of a photo array?
I think so. And it wasn't raised below that there was any problem with that particular.
That evidence came in though.
Yeah, I'm sorry.
That evidence came in.
Oh, yes.
Okay. So we assume it was after the law changed, but
yes,
still 11 years for a stranger.
Under extremely stressful circumstances, Judge, and even under the best construction of his own testimony for mere seconds in the middle of the night. He claims to be face to face with him. I don't think that really makes a lot of sense.
Look, and then he falls asleep twice during the trial, I guess. There's some indication. Seems like twice he fell asleep. Is that your reading of the record?
Yes, there's some issue with him not paying attention and just sort of not taking this really seriously at all.
There is other evidence, though. We get people, other witnesses who got some consideration,
right,
for their testimony. Jailhouse informant, some people call them. Sometimes they'll obviously lie to get a deal, but not always. But we got a number of them here. So what do we just assume they're all lying?
Well, I think a couple of things, and I'll get to this in my Singer point in a second. But they had a lot of this testimony from Cedric Wilson and a bunch of other players that kind of end up testifying later back in 1997. They didn't go forward on that. And I really think it's fair for this court to conclude, and I am asking this court to conclude that if you get rid of Dyson's testimony, everything else becomes extremely shaky. And I think the prosecution thought that as well. I'm sure they're going to say something like in response to the Singer point, we don't think we had enough in 1997.
Those issues dovetail, don't they? I mean, in terms of the shaky evidence and whether or not you can bring these charges.
Well,
There's something, right? Because I mean, there's a delay, but in 2006 is when Carvin appears as a witness, and he's got some details that are pretty important.
Right.
He says, I was there, I saw the defendant there and he was carrying two guns,
Right,
which is a significant fact here. And that one of those guns was a 380.
right.
That's a significant fact.
Yes.
But that doesn't happen. I mean, and that's part of the testimony that comes in trial, those details.
Absolutely. And the court doesn't have to credit the testimony. And this just gets to the weight of the evidence kind of analysis that this court has to make, I think, on its own later, just in the weighing things out. But I think there is ample evidence or ample reason not to believe the testimony of these highly incentivized drug dealers. They don't really they have information about the case, but it's clear that within a week, a couple weeks of this murder, that there's rumors on the street that Pulley did, and sort of all the features of this shooting itself, kind of the rough sketch of it, is on the street by, I want to say, maybe March or so, when they hear from, maybe it's Lamont Moore, I'm sorry if I'm getting this wrong, from Lamont Moore, who sketches out all the features of kind of the transaction as it happens. He doesn't have all the ID evidence, but it's clear that Wilson and all these other guys, Flagler, Duval, all these guys who are later involved, have a way to know what goes on or what might have happened in a rough sketch of things. When it gets down to the nitty gritty of the little details that they have to know about, they get it all wrong. They can't agree with themselves. And moreover, they don't agree with Dyson. We have the testimony about the pure player, this bright orange lettering on Pulley's shirt, supposedly, that Dyson doesn't ever really see. That's maybe the most vibrant identification evidence that's given from these other guys who are incentivized perhaps to not tell the truth. And Dyson doesn't come up with that at all. So I think if the court is looking for harmony between the details that these drug dealers give at trial and what Dyson says, or even any of the objective facts, that falls short. But unless there's any other questions on that, I'd be happy.
So there's other convictions, robbery, CPW, and all that. What if we were to agree with you on weight of the evidence on the murder? What then becomes of he got significant time on these other ones.
Yes.
What then for them? Were the police conditioned on the validity of the murder conviction? Or would they stand alone?
I believe they stand alone. He pleads guilty for consecutive time. We've asked the court to, and I'm not sure if the court is making reference to perhaps like a Fubizato type issue.
Well, that's what I was asking for.
What we analyzed that we're not asking the court to vacate the kidnapping assault case. We haven't raised any issues with respect to that. So we're not asking for that. We've raised a purely legal issue with respect to that second CPW case. And that should go away. And that's our own analysis of the case.
Right. You want to talk about the Singer issue real quickly?
I do, Judge, if I could. It's our position here that, consistent with Regan, and I've read the Tyson case as well, that the police, and this is a quote from Regan, they failed to employ readily available legal procedures to move this case along. By the end of 1997, they have all the physical evidence in the case, which of course they gained right away. They have not even a rough sketch. They have a full description of how the crime occurred. They have Mr. Pulley as the suspect. They've even interviewed him shortly after the shooting. And by the end of 1997, the police have in their possession two confessions from people who allegedly witnessed the confession themselves, Lamont Moore and this person named Holmes. Notably, the police don't do any identification procedures with those people at all. They have purported confessions relayed to them by two other people, a guy named Manigault, another guy named Thomas, who Mr. Pulley allegedly confessed to. The police do one ID procedure with one of those two folks. He identifies Mr. Pulley. They don't do an ID procedure with anyone else. And by the end of 1997, they've spoken to Zedric Wilson, who ends up being a really important witness for them at trial, who describes this, albeit circumstantial, but important idea that Mr. Pulley heard where McGee was, picked up these two guns and left. And that coupled with those two confessions gives the prosecution a lot to go on.
They had Dyson from day one.
They had, right.
And his memory's not getting any better. Over. Was it your position that they could have gotten indictment on Dyson at that time with his eyewitness testimony, and they didn't need.
Well, not in 97, of course, because in 97, the police determined he can't ID anyone. But I think
Well, and you know the case better than I do, but the police determined he can't ID anyone.
right.
And then later he's the key witness at trial against the defendant. How does he go from, we can't even arrest him because we don't believe his we don't think he's got a good enough ID, to now he's the star prosecution eyewitness?
I mean, that is precisely the point I make with respect to my incredibility as a matter of law. I think if you just sort of take the police's investigation at face value and kind of how it proceeds, at that time, Dyson can't make an indictment, or he can't make an identification, so he wouldn't really be the basis at that time.
He can't or he won't. What was the testimony at trial?
Well, the testimony at trial was not relevant to the decision on the Singer point, because Dyson hadn't testified at that point. So the only thing that the lower court could do was make its analysis with respect to the papers before it. And I think that actually makes it very easy for this court, as it did for the lower court, because it's all spelled out in the defendant's motion papers, which is adopted wholesale by the prosecution. I'll note, as I did in my reply brief, it doesn't go the other way. Defense counsel didn't adopt the prosecutor's version of events. The prosecutor and the court adopted the defense counsel's
Well, I guess
version of events.
Justice Curran's question is legitimate, and that maybe the police, the reason they didn't go with Dyson then is that he was afraid to testify, not that he couldn't make an identification.
There's no evidence on this record, particularly with respect to the Singer, and I think this gets to the heart of the analysis that the court has to make, that they delayed investigation because of that factor. And that's what they have to show. They have to show that they made and this is from Regan again, that they made a good faith determination to defer commencement of the case, or that they made some strategic choice to, in this case, we're looking at after 1997, they made a strategic choice to do nothing for 8 years. And I think that is not a credible or good faith explanation. In fact, I'll take that back. There is no explanation for what happens after that 8 year, or after that 8 years, or during that 8 years. And there's certainly no evidence on this record that they delayed because of Dyson, or that they knew he would come up with something later.
But wasn't there also, though, at that time in the early stages, some other suspects that they had to rule out? There was a suspect named James Prose who admitted at one point to killing McGee.
That is a factor in this case. However, neither the prosecutor nor the judge finds that there was any delay, that any delay was occasioned by the entry of this Prose's name into the mix. It seems clear, in fact, that they're focused on Pulley almost from the outset, because they interview him right away at his parole officers meeting, and they're really focused on him. There's no evidence they did anything other than just obtain Prose's name and just kind of noted that in their file. But it's clear that for example, from Zedrick Wilson, who I think gives some evidence maybe in September, that they got Pulley picking up these guns after hearing where McGee is and going out. I mean, that's got to be that is a factor that should have incentivized them to at least get identifications from these folks who say that he confessed to them.
Yeah.
But they do nothing.
The police and prosecution often get criticized for rushing to judgment, fixating, just going with it. Here, they did the opposite. They wanted to take a careful investigation and look at everything before indicting. And now they're getting criticized for that. But that's the factor too. Let's assume that goes your way. The extent of the delay factor 1 definitely goes your way. What about factor 3, the nature of the underlying charge? Do you want to? There's some indication from the Court of Appeals that it's not the seriousness of the charge, but the complexity of it.
Sure. Again, in this, I think the Court of Appeals speaks to, in Regan, this situation where, for example, there's no statute of limitations, and the complexity of the case might cause them to proceed more carefully. Obviously,
Was this a complex case in your view?
I mean, not by the end of 1997. And at the end of 1997, they have the whole scenario sketched out in front of them. They know who their suspect is and who they have to talk to. And this isn't a case, to respond, Judge Lindley, to the comment that perhaps the police proceeded with caution or contemplating. There's no evidence that throughout this 18 years, they're employing any strategy or doing anything at all. I think the complete absence of any evidence over that 8-year period leaves this court with just really a hole and of course, the prosecution has to demonstrate what they did in that time, and they did not. And it would not be a fair reading of the record to conclude that they proceeded with caution when in fact there's no evidence that they did anything at all.
Doesn't the lack of a strategy weigh in their favor, though?
No, I think Regan explicitly says that they have to that in order to establish good faith for the delay, that they have to show that there was a reason or contemplation around why they did not go forward. But at the end of 1997, we have at least 2 people who supposedly could identify Mr. Pulley as having confessed to the crime, plus the whole sketch of the crime, plus Zedrick Wilson, and then they wait 8 years.
What was the delay in Regan again? What was the year? Remind me.
In Regan, it was
Something quite short. It was
maybe 4 years. Yeah.
that
so-
decision changed the landscape on these. I mean, we never considered 4 years to be an extraordinary delay. The Court of Appeals dismissed the 4-year delay there, which was, we've got what, triple that now here.
And that's just one of the delays I'm talking about. I don't want to run out of time, but yes, and I think
It's a little late for that, but.
I'm sorry. Okay, I'm sorry.
How about the fifth,
Make sure I move
how
along.
about the 5th factor, whether there's any indication that the defense was impaired, any prejudice?
Yeah.
How was your client? Usually it's to the defendant's benefit. First of all, stays out of prison for quite a while, assuming guilt. How was he delayed how was he prejudiced by the delay?
The court, I think, in Regan explained that they don't put a ton of weight onto that. Mr. Pulley is prejudiced because throughout this time, there's rumors that he's a killer, that he's killed this person. We have one of the primary witnesses, this James Thomas, dying in the interim. But the Court of Appeals in Regan also says that a defendant might rarely be able to demonstrate actual prejudice. Because of the length of delay in this case, I think the Court of Appeals assumes prejudice and the burden shifts to the prosecutor to talk about good faith. If I could just, I must be far beyond my time, Judge.
That's right. It's an important case.
This case doesn't just have an 8-year delay between 97 and 06, which is the first time they talked to Carvin. There's also a 2-year delay after they talked to Carvin. Now they have this important evidence from Carvin. Carvin says that basically it's important testimony for the prosecutor at the trial that he sees Pulley seconds before the killing saying, I'm going to shoot this guy. He's got 2 guns in his hand. I think he might have said one is a .380. He lays out this whole scenario. It's clear, we find out later, and I'm sure the police knew at the time, they've known each other for 20 years, and there's no request for an ID procedure. That is right in line with Regan, where Regan faults, kind of going back to your comment a second ago, Judge Lindley, that it wasn't, Regan is a change, I think, not only because of the time period that the Court of Appeals saw as being excessive, but also because of the analysis that they made in terms of zeroing in on what the prosecutor did in that time or what they could have done and how they delayed things. We don't know anything about what happens between 06 and 08, but we know the prosecution could have asked Carvin to ID Pulley in 06, and they just didn't. And there's no explanation as to why they didn't do it. These guys know each other. Carvin gives important evidence that they just didn't do it. That is extremely important because of Regan. And 2 years is a long time, and it's not as if going back to the theme you raised a minute ago, Judge Lindley, it's not as though there is any evidence on this record that they proceeded with caution or maybe investigated other people in that time, or that there was any friction in going forward at all after 06. But they wait until 08. Now they get an ID from Carvin. Dyson kind of falls into their lap at that point. And then even after that point, they wait another, I think maybe from October of 08 until August of 09 to arrest him. And there's no evidence of any activity in that time. I don't know if 9 months is enough to win this case over, but here we have 8 plus 2 plus 9, and it's kind of plus 9 months. And it's showing a lack of diligence without a record of any explanation in the interim. And even in the Tyson case, for example, the Court of Appeals kind of analyzes what's missing during this. And for them, they kind of, I think, zero in on a 9-month delay after these lab results come back. And they say, well, we're not faulting them for trying to improve their case in that time. And I think that's what kind of saves the day in Tyson, because initially there was this view that perhaps Tyson could have been indicted right away because you have testimony from the corrections officer, et cetera. But the prosecution waited until they got the lab results. And I think that although that might have carried the day here in this court, when the Court of Appeals reviewed it, they looked and analyzed what the prosecution was doing in the meantime. And that lab result and the fact that they wanted to get that lab result to improve their case was important. We don't have any of that here. There's literally no evidence of that because of an 8-year period. There's silence on that subject. And even in
They were clearly concerned about the credibility of the witnesses, right? And isn't that why they delayed so long? And they were trying to get more evidence.
They were.
Regan basically says that there can be prejudice against the defendant. But it can't be like undue prejudice.
Well, they might have been concerned, and that might be true, Judge. They might have been concerned about the credibility of Wilson, et cetera, and their ability to proceed on that. I would ask the court to keep that in mind when it's deciding my weight of the evidence.
Yeah, it cuts both ways.
But if this court, for the purposes of the Singer analysis, if this court is going to accept that conclusion as maybe saving the prosecution's actions in this case, I think the only way the court could look to that conclusion is to look at, or to obtain that conclusion, would be to look at what they did thereafter. So we don't think Zedrick Wilson is really that credible. We don't think any of these other guys who police supposedly confessed to are that credible. We're going to go and complete the circle. We're going to find out about other people. We don't know why they only reached Carvin in 2006. We don't know. They don't even explain. Carvin was evading them. Other people were evading them. They couldn't get anybody. There's no evidence that someone was unwilling to speak to them. Dyson says that later, but he's got to come up with some explanation as to, why he's so drastically different, years later, and his memory is just so good.
Mr. Everett, I've been looking for this one thing, and I don't know, I can't find it in the defendant's motion papers on the Singer issue, but it looks to me at the appendix at page 84. The people explained they had no eyewitness who was able and willing to identify. So
Right.
That was an issue that they've raised right from the beginning about the willingness of the eyewitnesses, correct? So it's not just can't, it's won't.
Well, that goes to the issue that I raised earlier in terms of what the status of the record is and how the lower court resolved the factual issue. So defense counsel laid out his whole chronology in detail. The prosecutor's motion paper said, we adopt that version of events and then maybe add in some additional, and that's a conclusory allegation. No one was willing. There's not really any factual description of why that was true. They certainly don't reveal any of this stuff that Dyson says later. So we don't know that for the purposes of Singer. And then the lower court specifically says, I'm resolving this factual question based on the agreement between the parties, which of course is the prosecutor agreeing with the defendant, not the defendant agreeing with the prosecutor. So if the prosecutor added that later, it is not part of the, and this is almost like stipulated facts. It's something outside of the stipulation that these two parties made. And,
We'll take a look at it. We have, rest assured, reviewed. I know you have a lot of other issues here. You probably wanted to get to them, but you've outlined them in your brief very thoroughly, and we will review them as well.
Thank you very much, Chuck. I appreciate the extra time. Thank you.
Good morning, Amy Wallensack on behalf of the people. I'll plan to address only points 1 and 2 unless the court had any specific questions about points 3 through 6 in my brief. Starting off with the weight of the evidence issue, I don't disagree that this court has a legal determination to make regarding whether or not Mr. Dyson's testimony was incredible as a matter of law. However, I would argue to this court that his the record does not support such a finding, and I would argue that the jury's credibility determination on this record is entitled to deference by this court. Mr. Dyson did provide an explanation to the court as to why he did not identify Mr. Pulley as the shooter back in 1997, he explained that his girlfriend, who was in the car with him at the time of the shooting, did not want him getting involved. And it was after the shooting, and he was speaking with members of her family, I believe specifically her son, that they continued to tell him, do not get involved. We don't want to be involved in this criminal prosecution. And he deferred to them until such time that they were no longer in a relationship. I believe at the time of trial, he testified that she was in a nursing home. They seem to have broken up at some point. So there's no
Was the defendant in custody on another charge when Dyson eventually got around to cooperating?
I am not positive on that, Justice
That-
Lindley. I don't
I
believe,
know they got him on some new charges, but I wasn't sure if that was.
I honestly don't remember the exact timeline of because there are obviously three separate indictments in this case. The CPW indictment kind of goes hand in hand with I should back up. There's the murder and a CPW indictment. There's the CPW indictment that stems from when defendant was picked up in his vehicle to be questioned about the murder charge. And then there is the robbery, assault, kidnapping.
I interrupted you, I'm sorry.
Oh, no. But yes, so there's that robbery one. I just don't specifically recall the
That could
timing.
explain the change of his mind. It's one thing to cooperate against a guy in the streets. Another
Yes.
guy he's doing 8 to 10, it's a little easier than the latter.
Well, and also, I don't think it's an unreasonable explanation that if your significant other is strenuously telling you that I don't want you involved in a criminal prosecution, I don't think it's an unreasonable human reaction to not take your significant other's thoughts on that subject matter into consideration. If you testify in this murder trial, you're potentially putting them and their family at risk as well, depending on the dangerousness of the defendant. And again, I think that.
I think Mr. Abatoy's point, is that statement that I quoted a minute ago from the responding papers of the people about willing and able.
Yes.
Is there any evidence that you know of that's in the record that the police knew that explanation from Mr. Dyson at the time back in 97 or 98, whatever?
I would defer to the exact page numbers. I know there are several in this record. But I do believe that when the police were discussing in one of the timelines that's laid out, I believe they mentioned that Mr. Dyson did not identify or said that he was unable to make an identification. So
As opposed to unwilling.
yes, but I also do know that when a lot of these affidavit or reports are drafted, I think that sometimes we can quibble over the exact meaning of certain words that I think people more colloquially would just say unable to, and think that kind of covers an entire ambit of unable to because he doesn't want to cooperate with us. And again, this is information that the police would have known in 1997. And I think I recognize that there are some credibility issues with Mr. Dyson's identification, but I think defense counsel at the trial laid this out before the jury. There were hundreds of pages of cross-examination of all of the witnesses and their identifications, and then he argued strenuously in closing for the reasons that the jury ought to reject the people's evidence. The jury heard all of that and still chose to credit our evidence. And I think another fact that should reassure this court that the jury reached the right conclusion is the trial judge who presided over this entire proceeding, heard every single witness testify, said at sentencing that I, again, heard all of this, and I think the jury, I agree with their verdict. They got the right result.
I've heard the argument before, well, a witness whose testimony doesn't make a lot of sense, he was vigorously cross-examined about it, and the jury heard all that. Well, if the witness still had no legitimate explanation for these discrepancies, that doesn't provide a lot of confidence in the jury's verdict.
I would submit to this court that Mr. Dyson did provide a reasonable explanation for why he was not willing to come forward in 1997. However,
discrepancies in what he said he saw then and then later. And
I don't know that there was a great discrepancy in that. I mean, he was consistent that he saw the shooting occur and he saw the shooter go across. I think the thing that changed was that he was willing to, in 2008, say who the shooter was.
Well, there's more than that inconsistent in terms of him turning around and coming back to the scene and getting out of the car and that type of thing. But let's assume if we discounted all of that,
Sure.
there's the position.
Yes, you kind of stole my thunder,
There's
Justice Del Conte. I was about to say that even if you were to disagree with me that Mr. Dyson's testimony carries no evidentiary value, there is still enough evidence in this record, I think, to support a finding that the verdict was with the weight of the evidence, because we have Mr. Wilson, who testifies that he met the defendant on the night of the shooting, had just revealed where the victim was, and then saw defendant take two guns, I believe it was a .38 caliber and a 9mm, and leave in a hurry. We also have Mr. Larkin, who kind of consistent with that, saw him take the guns and leave in a hurry after finding out that the victim was at the G&G stakeout. Mr. Larkin also ran into the defendant a couple weeks after the shooting, where he told Mr. Larkin that he got the victim and that the 9mm gave out on him, which would be consistent with the physical evidence that the police collected in terms of the projectiles that were recovered from the victim's body were consistent with being from, I believe, that .38, the .380 caliber. And I would have to defer. It's been a little bit since I read the trial transcript, but I believe there was some indication there might have been a 9mm shell on the ground, but that there were none recovered from the victim's body. And we also have Mr. Carvin's testimony that he also saw the shooting and saw defendant shoot the victim in the back, which would be consistent with the autopsy report finding that one of those bullets did enter through the victim's back and I believe lower side. So I think even if you were to exclude Mr. Dyson's testimony, there is still enough evidence to support the verdict that the jury reached in this situation. And so unless the court has any other questions, I'll address the Singer issue. So I would adopt or refer the court to the prosecutor's response that Justice Curran pointed to. The people didn't have a witness that was willing to identify the defendant in 1997. And all of the descriptions of the various individuals that were mentioned in defense counsel's papers, what's notable is a lot of them provided hearsay information. It was rumors, what I heard on the street, or this is what people in the neighborhood think. Respectfully, the people couldn't get an indictment based on what, somebody's neighbor said about the shooting. That would be a complete abdication of our ethical responsibility to not obtain an indictment unless we believe we can prove.
I don't want to jump too far ahead here, but I want to look, if I could jump to 2006 though.
Yes, of course.
In 2006, Carvin says, I saw Pulley, two guns. You've got all the information. The defense says nothing happened for 2 years, which is indicative of the pattern in this case. Do you disagree that nothing happened in investigating this case after Carvin gives the investigators everything they need until 2008, 2 years later, that Dyson is approached again?
I have to defer to what the record says here. I don't believe there was any information that talks about an additional identification proceeding. But I think if we were to conclude that 2 years was not that we could have moved with further haste, I don't think that 2 years alone is an unreasonable delay that would then result in a speedy trial violation.
That 2 years alone, but you don't disagree that 2 years, there's no explanation in the record for why nothing happened investigative like during those 2 years.
I don't recall that there was any explanation, Justice Delconte, honestly, but I also think that the way that this was framed to the trial court by defense counsel below was that it was the 12-year gap. I don't believe in the motion papers that defense counsel made the argument that is sort of being advanced now, that this 2-year gap in explanation alone resulted in the speedy trial violation. And I don't think that that is what the lower court below decided. So I think we're kind of left with the way that this was framed by defense counsel below, which is that we have to look at the 12 years, and it is the 12-year in totality gap that is what results in the speedy trial.
There's 5 factors. The first factor is the extent of the delay. You would concede that militates in favor of the defense.
Yes, I would say that does generally weigh in defendant's favor, but is not dispositive.
Not dispositive. You got to go through. Second factor is what we've been debating. You're making arguments. Reason for the delay. Close call there. Fourth factor, the defendant was not incarcerated. That
no.
Is in favor of the people.
And I would also posit that the third factor is in favor of the people.
I was going to get to that. So the third is the nature of the underlying charges / complexity of the case. What's your thoughts on that?
Well, I think the Court of Appeals has repeatedly said, and I believe I quoted to one of this court's decisions from 2011, Donahue, that I don't think there's much debate that murder is inarguably a serious offense. And I think that when we get into the complexity issue, I think that there is much more involved in this particular case. We have ballistics evidence, we have an autopsy, we have collecting these witnesses at a time at which they're willing to testify.
But would you agree? We used to think that it was just, if it's a serious offense, that's factor 3. Court of Appeals' recent clarity is not so simple. You got to look, there's a murder case can be very simple. It's an assault third where the victim's not around. It's an assault case, I should say, without a victim to testify. Doesn't necessarily explain a delay in prosecuting it.
I would say that we do have to consider more than just the nature, but I do think that still the fact that this is a murder case does weigh heavily in the people's favor. I don't think that the seriousness has completely been taken out of the equation. And that is why the legislature has chosen not to even impose a statute of limitations on murder, showing again how serious the people of the state of New York take these types of offenses.
The reasons for the delay can also be weighed with respect to the seriousness of the offense and how complicated it is. I mean, if you don't have DNA evidence, if you don't have other direct evidence, you're waiting for somebody to step up. That can also reflect, because I think in Taranovich, it says it's a holistic assessment of fact.
Yes, I agree, Justice Kern, and I believe the Court of Appeals just recently reaffirmed that in a case called People v. Tyson, which I believe you may have granted leave on. So you have to consider all of this in totality, not one factor should be determinative.
How about the fifth one?
The fifth.
The prejudice, counsel argues the Court of Appeals kind of discounted it. It's not a full factor, maybe 4.5 factors. Do you agree with that?
Respectfully, I would disagree. It's still a fifth factor that they have directed in Taranovich should be considered as part of this holistic assessment of the speedy trial violation, or alleged violation, I should say. And in this case, I don't think that there was any demonstrated prejudice to the defense other than the passage of time, which frankly respectfully cuts both ways. But I think any alleged prejudice was with regard to Mr. Thomas, who had been driving the vehicle and dropped the victim off at the G&G stakeout. And again, all that is in the record is that he was unable or unwilling to provide anything other than hearsay information about the murder back in 1997. I think that any alleged prejudice with respect to his testimony is speculative at best, that he was willing or able to provide anything other than hearsay. And unless the court has any further
If
questions.
I could just real quickly on the Batson issue.
Oh, of course.
There was a prospective juror who was challenged for cause by the prosecution.
Yes.
The reason the defense challenged it and said the response from the prosecutor and the ruling from the court was there's no pattern of discrimination yet. That's not a valid basis, right, to deny. I mean, you don't get one free discriminatory strike.
No, you don't get one free discriminatory strike, but I definitely think that the court could have been more articulate in describing its Batson analysis on the first one.
Yeah.
However, I would point this court to its decision in People v. Boyd from 2020. I did note in my brief that the judge from People v. Boyd is the exact
Right,
same judge,
yeah.
and
I mean, there's arguably a Concepcion issue, but the judge, 4 out of the 5 saw no Concepcion issue there.
Yes.
One did, but that case, same judge, same issue. We affirmed, I wasn't on it, but we affirmed saying the defendant didn't meet his initial burden.
Mhm.
That wasn't the ground the court denied the Batson challenge on, but we affirmed it anyways.
Well, I think that reading the analysis in this particular case, I think everybody is focused on the fact that you haven't shown a pattern of discrimination here. And so I think at step 1 of Batson, there are 2 ways that the move-in of the Batson challenge can go about showing that there is an inference of discrimination. You can either show a pattern and say that they have struck now, say, 3 women jurors, prospective jurors from the panel. But I think if you don't have the pattern, then you have to give some sort of facts that would lend itself to the inference of discrimination. And I don't think here, so I think when the court is saying, well, there's no pattern, that was one way defense counsel could have.
What about defense counsel's follow-up point?
Well, I think when he follows up, everything that he says afterwards, I think kind of undercuts that inference of discrimination, because he keeps saying, well, I understand that I believe it's nephew or son, one of the jurors had a son, but her nephew pled guilty to murder. And I get that, but she did say she'd be fair and impartial. And he keeps undercutting his own arguments that there is an inference of discrimination outside of this pattern. And I would point this court to the transcript in Boyd. If you compare the two transcripts, they are pretty similar. I don't
But
know.
your position, I think, is that we could affirm this and we don't have the conceptual problem if the challenge was so vague and conclusory at step number one.
Yes, and
But
that
if
was
we were to
something.
read the follow-up as actually asserting a prima facie challenge, then Boyd wouldn't apply here, would it?
I respectfully, I didn't read the follow-up to raise an inference of discrimination, but I don't think that anything that was said in that follow-up deviated from the transcript in Boyd, respectfully. And again, I think that the part of why this court in Boyd concluded that there was no Concepcion or LaFontaine issue was because the way that the trial court had phrased his denial of the Batson challenge kind of encompassed that step one finding. And so it's kind of within what he said.
Right, there are two reasons the defendant can fail to meet the initial burden on a Batson. And the judge here relied on one. You're asking us to affirm on another, but it's still the same level of Batson challenge. Still
Yes, and I think it's within that finding that the step one was not met. And unless the court has any other questions, I would rely on my brief and ask you to affirm all convictions.
Thank you. Case number 364 is People versus Anna Galland. 364. Mr. Keem, good morning.
Morning, Your Honor. May it please the court. I promise I won't be as lengthy as the last argument, but it was very interesting. Here, Galland had a genuine fear of revealing additional information relevant to her CPL 21040 motion. She requested to present it in chambers. The trial court declined that request, and we assert there's just no legitimate reason for that. It was relevant to the 21040 motion, so we'd ask the court to remit it for a proper determination on her motion. We also assert that even without that evidence, she established 21040 interest of justice, a reversal. If there are no questions about that issue or our sentence, then we'll rely on our brief.
Thank you, Mr. Keem. Next case is People versus Chauncey Cruz, case number 365. Good morning.
Good morning, Fabian Santacroce for Mr. Cruz. I plan on discussing point 1B, point 2, point 3, and then just briefly the last 2 points, which kind of go to errors at sentencing. The belated disclosure of body-worn camera footage on the morning of jury selection was a violation of CPL 24520, and I don't believe the remedy or sanction, which was preclusion, was appropriate and proportionate to the prejudice suffered by my client. In essence, the district attorney said they were not going to use it on their direct keys. So
This is down the weighing and big numbers. Is that your point?
No, I'm actually not talking about 3030. I'm actually going to sanctions. If you want to talk about 3030, we can. I was going to go.
I missed that. Sorry about that.
Yes,
We're
he was sanctioned. Sorry.
When we're prejudice is the consideration on a sanction, don't we need to know what was on the video?
Well, I think that's discussed what's on the video, which is the fact that she did tell the police that there was a second rape, perhaps, and that was never disclosed before. And from that point forward, her story changes. From that point forward, it was just one time. It wasn't after 7/11. That's huge.
The defense want that into evidence. Like, why would
we not want that in evidence?
Yeah, it sounds like that.
Well, I think it's
exculpatory.
It's a prior and consistent statement, but it's something that's not your typical prior and consistent statement, Judge. I don't think it's that easy to decide, do we want to or do we not want to? He obviously didn't want to, because the strategy, he did not put it in. He did not impeach her with it. I think there was concern about what what that evidence would do. But the reality here is it's Brady, it's Rosario. This is information told to police. The first police officer that she spoke with substantively, a female officer, and there was this second incident that happened after the 7-Eleven, and it is not disclosed until the morning of jury
So
selection.
this is the body cam of the complainant.
Yes, this is the body.
Right. I just want to make sure, so forgive me,
is-
because we have a lot of cases, but
I understand.
I
Yeah,
just
no.
want to make sure I.
Actually, don't go through the facts because, of course, it's body worn camera footage. As a
This is Brady material because it tends to exonerate your client.
it's impeachment.
Okay, but still Brady
Yes,
could be favorable to your client.
yes,
It's not turned over in a timely manner. There's a motion for a sanction. The court
Correct.
then precludes this evidence that would help your client.
precludes it on the DA's direct case.
Yeah.
And they had already said, we're not going to use it,
But
clearly.
the defense could have used it.
Well, of course they could have, but this could have changed the whole theory of the case. We know that she told the first doctor that there was some incident after 7-Eleven. We had no idea that she also told the police that and that they perhaps buried it. At worst, they buried it.
Was she asked about this on cross-examination?
No, she was not.
Could she have been?
Of course, that goes to strategy, of course. Again, I also think it's important for the court to understand this was disclosed to him the morning of jury selection. He doesn't even get to watch it until he picks more than half of the
Would
jury.
adjournment have been a better sanction? Like, let's adjourn the.
Yeah, obviously he went for the gold. I mean, he went for preclusion of her testimony or dismissal of the case. The judge didn't offer any other option. It was he had made his decision the day before, to be completely honest. Justice Renzi already said, I'm probably going to preclude it. And then the next day.
You're saying the defense lawyer went for the gold by asking for preclusion?
I'm saying the defense attorney went for the gold by asking for
Dismissal.
for preclusion of her testimony and dismissal.
Okay, I get you. Okay.
No, but I'm telling you that Justice Renzi,
Yeah.
before even knowing what was on that video, on the body-worn footage, said, I'm probably just going to preclude it. And the next day did so. But this could have changed the theory of the case. I'm not sure. It's very clear that after that moment, her story becomes just once. And that is in her supporting deposition.
This crime is captured on video. It's a highly unusual case. It's on video for all to see.
Yes, it is. Yes, it is.
It's so this evidence, you think, would have undermined her story as told to the jury and as shown in the video that he took of him raping her?
Well, it could have undermined that if the sex afterwards was consensual. We don't know because it wasn't explored, because it was turned over again the morning of jury selection. He doesn't even watch it until that night to know, oh wow, she also told the cops there was a second one. And they chose to keep it out of her supporting deposition. They chose to keep it out of the grand jury. They chose to not put it in their report. In fact, the DA tries to minimize the prejudice here by saying, oh, well, you had Officer Soliday's report. Officer Soliday's report omitted the second incident as well. I don't know what it means, but I think that you should have that in enough advance to decide what's going on here. Why did the police bury this afterward? This is a serious case. And yes, you're right. It was on video, and did not intend on arguing weight of the evidence. I personally think that it was more of a no means no. It was disturbing. That was given, through the defense attorney. But I think this is a serious violation to hand over a body-worn camera that has Brady and Rosario the morning of jury selection, and you're not even able to watch it until you've started picking a jury. And obviously, I've already picked your theory of where we're going with this. I'm really not sure. I did trial work for 11 years. I'm not sure what I would have done with this either.
Wouldn't you have at least asked her, wait a minute, didn't you say you had consensual sex with him after you claim you were raped? I mean, wouldn't you?
Well, it's just
ask her that question?
so I guess that could go to ineffective assistance of counsel then,
Okay.
there's obviously,
I don't know, it doesn't seem like some
there's a-
decent strategy here.
I wasn't the trial attorney, but the defense attorney was very into duplicity, as you know, which I think was off base. Instead of perhaps using it as a prior inconsistent statement to impeachment. But I presume you all may say that's strategic, or you would say that a reasonably competent attorney would not have done that. I wasn't going to move to point 3 yet, but I'll, if you'd like, I can move on to point 2.
Wherever you want to go, it's your argument.
Thank you. As for point 2, the Molyneux notice only noticed one specific incident, and then otherwise was very general. the defense attorney, I think, did preserve it by saying, this is a generalized description and then objected. And the court noted, the exception and said, well, I'm letting everything in between these dates, meaning everything in of DV history. And then all this at trial, we're way off from what was in the notice. I mean, way off. We're talking about, she actually never even testified to the one specific incident that actually was listed in the Molyneux notice. And, Molyneux now is codified, under CPL 24520. It says you're supposed to list all of the misconduct and criminal acts that you intend to use. And here we have.
Going beyond the scope is unpreserved.
I think it was preserved because literally when they're having the hearing, the defense attorney says, I'm objecting for the non-specific nature of this. This is just.
Maybe I wasn't clear, but at trial, when your argument is when the Molyneux testimony came in, it went beyond what the court permitted. And I don't recall.
That's not what I'm arguing, Your Honor. What I'm arguing is that neither the court nor the defense attorney knew what was going to come in because it wasn't in the Molyneux notice. How could the court actually make a, probative value versus prejudicial effect analysis when he doesn't know that there's going to be testimony that would a dog biting her, pulling her hair, kicking her? This is not what was in the Molyneux notice.
Was there an objection to that testimony?
Unfortunately, I do not believe so. He made objections, but maybe not on that.
My point.
Understood. I do think that initial objection to the non-specific nature is getting at the fact that it's not specific. It's not listing out. He doesn't have 24520 in front of him, I presume, because it doesn't go to it and say, this is not listing out all of the misconduct. But I think if you look at what he says about alerting the court to the non-specific nature of these acts, generalized description, that's in essence kind of what we're getting at. I think it is saying you're not listing them all out. And clearly, I don't think the court had even the ability to do an analysis of probative versus prejudicial when was not aware that it was going to go this far. So I think it's a due process violation. And obviously, I think it is preserved by that first statement. So he can object again, but the court's already made a ruling. I'm letting everything in to these states. So the court's already said that. The court never gave a Molyneux limiting instruction. The defense attorney never asked for it. That, in essence, takes me to point 3 is ineffective assistance of counsel. Defense counsel at no point requested limiting instruction regarding the Molyneux evidence, which obviously could have been taken as propensity, not at the time of her testimony, and for the jury instructions. Appears to me to be an oversight, not strategic. He did object to the Molyneux evidence coming in and at the hearing. I obviously point 1A of my brief discussed a statutory speedy trial claim. If this court finds that was perhaps meritorious, he waived that issue by letting the trial go on and picking a jury. Once you start a jury, you can no longer make that claim. The adverse inference instruction, I think this is going to be the future for the court with generative AI. In this case, perhaps not the most important because my client did make admissions to the event happening, different rendition of it being consensual or not. But
it would have been a permissive adverse inference charge at most, correct?
Most, and it would have had to be one that was actually tailored to this case. It would not have been destroyed and missing. I admit that. And I didn't say that in my brief, but I think that's what the DA assumed I meant, which I understand. This would be one where when you have the opportunity to obtain metadata, you should do that. And if you don't, there should be an adverse inference. And I say that because with generative AI, which is increasingly realistic, without having metadata, you don't know, you cannot authenticate or not. So I think this is the future for this court. This case, perhaps not the best example because of things said by the defendant, but I do think that that was also an error by the defense attorney. The court even told him, "I'll make that argument during the jury instructions." Obviously, we already discussed the fixation on duplicity instead of dealing with a prior inconsistent statement and using it perhaps in a better way. And last but not least, I just want to discuss the last 2 points, which are errors made at sentencing. The court erred in setting the duration of the order of protection by failing to take into account Mr. Cruz's jail time credit. Again, this is not about my client having the ability to contact the complainant any earlier. I would hope there would never, ever be any contact, but it's just about the
law, right, from your perspective.
It's just about following the law. It's just about Judge Renzi following the law. And That's all, that's why I'm asking for this court to correct that by, I think, approximately like 10 months. And last but not least, the DA and I do agree that this court should amend the certificate of disposition and uniform sentencing commitment to subsection 1 of 13050.
Again, we should get the law right and put the.
Yes, exactly. And that obviously will be important when my client is released and there will be a SORA hearing. And I think it's clear, but we can make it clearer. For whatever reason, it was that subsection 1 was left out, and it was continued to be left out and even through sentencing. So unless the court has any further questions, thank you.
Thank you, Counselor.
Good morning, Amy Wallensack again. I shall endeavor to be shorter with this case than my last one. I'll address the same points that counsel did unless this court has any particular questions about the remaining points. On the discovery issue, I don't think that the court here abused its discretion in crafting a sanction here. I completely agree that this evidence wasn't particularly helpful for the people. Defense counsel himself could have chosen to bring this in, but he chose to pursue a different strategy at trial. And I think with respect to the judge's
Do you
statement,
think this is Brady?
I think that this is an inconsistent statement about how this attack occurred. I did not.
Really, at a minimum, impeachment.
I think it's impeachment material. I do not believe this to be describing a second attack. I read this to be an inconsistent account of how it unfolded over the course of this evening, because they were clearly in one another's presence for several hours.
What precisely what was in that video?
I don't, Justice Kern, because it's not in the record. It was never entered into as a court exhibit. It's not a part of this court's record on appeal.
And you don't think it was Brady?
I think it was, I do think it was, it's an inconsistent statement. I think ideally it would have been turned over, but I don't think that the belated disclosure in any way undercut us exercising due diligence. There was other body worn camera footage that was turned over. This seems to have been an oversight despite the prosecutor's repeated requests for body worn camera footage. And I believe defense counsel himself even acknowledged that the prosecutor used due diligence in this matter. He did not appear to cast any blame on her when they discussed this request. And again, I discussed in my brief that I don't think her repeated requests show any sort of lack of due diligence on our part, especially given the volume of other more relevant discovery that was turned over to defense counsel. I think that
Including body worn camera footage.
Yes, we turned over other body worn camera footage. And I think also, as defense counsel recently pointed out, the trial attorney was aware that she had made a statement that was inconsistent with this account. This is a second inconsistent statement that matched that first one to the same nurse. And then she clarified that, no, this is actually how the attack unfolded. So I don't think that there was such prejudice to the defendant that.
What did she say that was inconsistent on the body worn camera that was inconsistent with her trial testimony?
So her trial testimony is that the entire attack unfolded before they walked to this 7-Eleven to get food. Initially to the nurse, and it appears one of the police officers, she said that a portion of the attack unfolded. There was a break at which point they went to the 7-Eleven, and then the attack continued after they got back.
She didn't recant, or she didn't say it was consensual or anything like that. It was just, she had some timing difficulties.
Yes, Justice Lindley. And again, that timing inconsistency was disclosed to defense counsel with respect to the same nurse's report.
Wouldn't that the officer, because that's the first one that was there? Wouldn't the DA want to, just ask the officer about that? That's the first officer she spoke to.
I candidly, Judge Ogden, I don't recall the exact timing and which officer this was. I thought that this body worn camera footage related something to the hospital. I would defer to the record, but it's not entirely developed as well, which makes it a little difficult to discuss this on appeal. It may be more appropriate for a 440 motion, at which point the body worn camera could actually be discussed and admitted. But on this record, I don't think that we have enough to show that Judge Renzi abused his discretion in crafting an appropriate discovery sanction. And so with respect to the Molyneux issue, Justice Curran, I believe that most of the Molyneux contention being raised on appeal is unpreserved. The only objection that I noted in the record was to the specificity of the Molyneux notice. And I think that defense counsel frankly wanted most of this Molyneux evidence to come in because that was his theory of defense at the case, was that this was a dysfunctional relationship between two adults. And despite the disturbing nature of the video that you're about to see, you should not hold that against my client because this is what their relationship was like. I think that was a reasonable strategy for him to pursue, given that the jury was going to see this video. It's a very...
The video, it may have been the only strategy.
Yeah, I agree. And if he had objected further, he was going to have to put his client on the stand to testify about their prior relationship. This was a way for him to get that evidence out in the people's case in chief and use that for his summation, for his defense. I think that that was a viable defense. And I suppose getting back to the cross-examination about this inconsistent statement regarding the timing, I don't think it was per se ineffective to choose to pursue the defense that this was a dysfunctional relationship rather than hammering this sexual assault victim on the stand about quibbling over the timing of the attack. I think that he necessarily took note of what the case was and chose the defense that, in his opinion, was more viable. And I think
It was tough. He had to deal with the videos. There were multiple videos. That was tough to overcome for defense.
I agree.
We don't see that type of evidence.
We don't. And candidly, the videos are disturbing. And I would posit to this court that the evidence was overwhelming. I frankly think a different verdict would have been unreasonable. I don't make that argument before this court frequently. And I think with the Molyneux evidence too, the failure to request the limiting instruction, I think that goes back to, again, how defense counsel wanted to use this evidence. And I think any limiting instruction was going to put a cap on what he could argue to the jury for how they were to consider this evidence. So I don't think that failing to request the limiting instruction was ineffective on its own. And I know that this court has also said repeatedly that the failure to ask for a Molyneux limiting instruction is not, that single error is not so egregious on its own to constitute ineffective assistance of counsel. Briefly, with respect to the remaining ineffective assistance of counsel points, I would largely rely on my brief. I would just like to point out, though, with the permissive adverse inference instruction, under Handy, that instruction is appropriate when the police actually have evidence in their possession, and whether it's through inaction or deliberate action, that they actually destroy it. This metadata that defendant is referencing was never in the police's possession. It was on the victim's cell phone, that is her private property. They never collected it. So a permissive adverse inference instruction is just not, it would not have been given under Handy. And again, I would note that the order of protection issue is unpreserved, and I would ask this court to decline to reach it in the interest of justice for the reasons set forth in my brief. Unless the court has any other questions, I would rest on my papers.
Thank you. Case number 366, People versus Stephen Burr. Good morning.
Good morning. Erin McCampbell Paris on behalf of Appellate Stephen Burr. May it please the court. This court should reverse the convictions below because 3 sets of evidentiary rulings deprive Mr. Burr of his right to a fair trial. Each sets of these rulings provide an independent basis for reversal, and when taken in the collective as a whole, they demonstrate that before the very first witness was seated in his trial, he had no shot at a fair trial. I'm going to begin by talking about the erroneous ruling allowing the people to present testimony on the child sexual abuse accommodation syndrome. That's a bit of a mouthful.
Yeah, can I ask you a question about that? And you're, the defense attorney below wanted a Fry hearing, right? And
Correct.
part of your argument that there should be a Fry hearing.
Correct.
But the Court of Appeals and appellate courts have already ruled that it's recognized in the scientific community, correct?
That's actually, those cases I would argue are irrelevant because they do not have the record that is before this court in any of those cases. This is the first known instance where a defendant has put the scientific record before the courts. So we don't know how this ever eventually or initially made its way into New York courts, but it's been blessed by one court after another. And regardless of that initial ruling, the Court of Appeals in People versus Williams, its 2020 opinion, has crystal clear that courts are required to look at the state of the acceptance within the scientific community at the time the defendant makes the motion.
Yeah, look,
And so regardless of what was at issue, pardon me, Your Honor.
I looked at, as a result of your arguments, I looked at the history of this, and it is very puzzling that this is not even a scientific theory. The person who came up with it in 1983 just wrote a paper about it. This is not a scientific theory. It just explains behavior in some situations, and all of a sudden it gets admitted into a case, never been a Fry hearing, Daubert hearing in federal court. And we just keep citing case after case, but Spicola is one of the Court of Appeals cases. There's a number of them. I think your argument is in those, they did say it was admissible there, but it was, I think your argument would be on the record in that case. The defense really didn't make a challenge.
Exactly.
The type of evidence that you have. People versus Austin is a similar case that we've had.
Exactly. And in that case, you said that the bottom line was the defendant in that case had not provided a sufficient record as to whether this evidence was or was not accepted.
Right. All the defendant did in Austin was say it's no good. You say you have evidence that it's not a valid theory.
Correct.
Other states, too many to count, have their top courts have said this is not admissible.
Correct.
We've had evidence that we think is reliable that turns into junk science over time.
Correct.
We have bite marks.
Bite marks.
That used to be legit.
Polygraph.
Fingerprints, borderline junk science. Used to be people doing life on fingerprints.
Exactly.
Not very subjective. You're saying with this, let's just have at least in those cases, there's probably a Fry hearing. Let's have one Fry hearing here. What's the harm in, let's air out the scientific basis for this theory once and for all, and then maybe it goes against you, but at least you want to present your experts.
Exactly. I would argue, and, to reach for the stars here, that the record's sufficient for you to find this evidence inadmissible, but a much more measured approach would be to remand this case, to reverse the convictions, and to order a Fry hearing. I believe it would be the very first in the state, and I'm not alone in asking you for that request.
Has there been a Fry hearing or similar in another state?
So my understanding is that there were a couple of states, and the amici highlight this a little bit more strongly than I have, where it was put through Fry scrutiny, and the people in those states were unable to sustain their burden under Fry. They were unable to demonstrate that it's generally accepted within the scientific community, and for good reason. If you look at this record, Dr. London Newton testified that it is not science, it's not based on data, and that the most damning.
Based on that, and based on what Justice Lindley said, why would a Fry hearing even be what you would request here? Because a Fry hearing is supposed to be about scientific evidence, something that's accepted in the scientific community. And if this isn't a scientific issue, why would the judge order? I mean, that still wouldn't prevent the lower court judge from denying the admissibility of what a counselor is testifying to. I mean, like normally a lot of times in where a child's abused, the testimony you might have an expert testifying. It's normal to delay a report, for example. That could be accepted in the therapeutic community, but it's not a scientific.
Well, it was presented here to this jury as if it was something they could rely upon. And the problem with it is that these cluster of symptoms are as equally present in a case of actual abuse as in a case with no abuse. And so that's one of the key issues with this going in front of a jury.
Yeah,
So
I didn't get that. I saw that in the brief, that if people who aren't abused delay in reporting an abuse, how can that even be possible? You're delaying reporting something that never happened?
It'd be in the instance of a false allegation, right? So what Dr. London testified to is that this is present in both situations, which makes it useless for a fact finder.
Well, we've got New Jersey Supreme Court says no good. This theory. We got Washington State Supreme Court saying it's no good. We got Florida saying no good. We got the Second Circuit said it was highly controversial. Pennsylvania, I don't think, and
Kentucky.
Are there other states that have?
I think it's making its way through the courts in other places, but those are the ones where the highest courts of the states have definitively ruled that it should not be put in front of a jury because it's just not helpful for a jury.
My keynote up at the top of my page here is, it looks like we're a way station on the way to the Court of Appeals, ultimately, whichever way this goes. Getting sort of glomming on to Justice Greenwood's question, the way I have this in my head, and if I'm wrong, please clarify it for me. But there's competent evidence question and there's a relevant evidence question. For us to reverse on this record, we'd have to conclude it was irrelevant. And if that goes to the Court of Appeals, that conclusion might be reversible because they seem to think maybe it's relevant. So it seems to me your best remedy is to challenge the competency of the evidence, which is be remittal, and have it go back up on a full record, whichever
Yes.
way it goes.
I absolutely, but my initial request is that you just reverse and order it to be precluded. But my secondary request, which is equally as valid and supported by this record, is that you reverse and order a hearing for the judge to make these findings on a full record. The people should be put to the burden of establishing whether this is or is not accepted within the scientific community, and then the judge can make a proper ruling on the full record in front of her. And this court could then review as the Court of Appeals.
And again, just for the way I think about it, but we can't really get to the relevancy question until we know if it's competent.
Correct. And we haven't argued that it was irrelevant. We have argued that it should never have been put in front of a jury because it's not competent proof of anything.
And I should have read all these cases that were cited from the other states. I just haven't yet. But as you know, in New York, this theory is of very limited use. The expert can't opine as to whether abuse occurred. It can't opine as to whether the child is telling the truth or not. It's just generally, is there a delay? In some cases, do some child victims recant? Very general, not specific to the case. In these other courts that you're citing from other states, are they, because we've already said is that you can't come in and testify.
Correct.
There's a lot of things.
Yes.
Are they saying you can't use it under any circumstances in those courts?
My understanding is that they've taken different approaches. For example, there was one case where they looked at the particular factors that were at issue in that case. Not that the witnesses had looked, the experts had looked at the case documents and had made their own opinions, but just was that testimony relevant to any of the issues in the case? And so I think it's a similar situation here where we have the expert Surya Paj coming in, she's a therapist, and she says that here's these, symptoms, these clusters that are present in kids that have been abused. And it's, you can very easily extrapolate and see how the jury connected some dots here that were not otherwise established and used it to the defendant's detriment.
Well, I guess if it's not a valid scientific theory, you shouldn't be able to use it for anything, not even a limited use.
I would argue that, right? And I think this record supports it. The records in the other cases in the other states may not have been as strong as this one. I mean, this one is.
You came ready on this issue, ready. You had all the evidence lined up and experts ready to go. That's, you would say, is the difference in these other cases. They're just objecting to it without having witnesses or scientific objection.
Exactly. Mr. Burr's trial counsel, Dan Henry, did a wonderful job in assembling the record on this, both with his very fulsome and detailed pretrial motion asking for preclusion of this evidence and the evidence presented at trial. Right.
Now, where I take issue with the brief is you say he's convicted on this. I mean, he's convicted on the testimony of his daughter or of the complainant here. Did this play a role? Maybe, maybe not, but the central evidence was testimony from the complainant. That's the evidence that convicted him.
If we had a case where she testified and that was it, right, and he testified, then I wouldn't be up here making these arguments. But what happened here was a fundamental miscarriage of justice. You had the CSACE evidence, and I'm just going to use an abbreviation. You had this evidence admitted, which was incredibly prejudicial. Then the people sought and obtained an order to present testimony about these punishments that Mr. Burr purportedly inflicted on the complainant and her siblings. That was not a side issue, a small thing off to the side. That was front and center from the start to the finish of this case. 4 witnesses testified. There was graphic and detailed testimony given, and the judge did not even enforce her own limitations on this evidence. So even if you were to say that, Erin, you're way off base, she should be allowed to admit that evidence, she didn't follow her own rules on limiting it. It was basically whatever the prosecutors wanted to do, they were able to do and to get in. And it so poisoned this jury that I don't think there was any way Mr. Burr had a fair chance. And that there's another piece of this as well, which is that she allowed the defendant's brother to testify about a mirror that Mr. Burr had fabricated to give to the complainant. And when the display, the electronic display on the mirror was turned on, it displayed the words, "Hey, sexy." Mr. Burr immediately said, "I don't think we should be giving this to her that way, obviously." And that's the brother's testimony, not Mr. Burr's. She never saw it. It wasn't given to her. But this was put in front of the jury. Okay, it poisoned the jury. There is no allegation more harmful for a defendant to overcome than the charges he was facing, and now this extra allegation that he finds children, his daughter, sexy. It didn't provide any evidentiary basis for the jury to do anything other than to find propensity evidence against Mr. Burr. So this calamity of errors, and then the final one, he was very hamstrung. The court, severely limited what the defense team could do at trial to try to put on a defense. And the one that I think is most problematic is the preclusion of the expert to talk about suggestibility. In this case, we have a child who says that her, after being told her father is a pervert by a family acquaintance, she says that, he engaged in this conduct. She, contemporaneous with that, writes in a notebook that teachers of hers physically abused her and sexually abused her, and that she writes, "I don't know what the truth is about my dad. I honestly don't know what happened." She then goes through the forensic interview and through therapy, and ultimately we get what is on, her saying what she's saying on the stand here. So between the neighbor or family friend calling her father a pervert or some kind of a pervert, I think was the testimony, and then this process, I think it absolutely is a situation where defense counsel should have been allowed to present expert testimony on suggestibility, especially because in this case, you had the other side of the story, which was the testimony about the CSACE theory. So,
But the defendant agreed to the CSACE.
no, absolutely not. He objected to that from start to finish throughout the trial.
He didn't agree that it was generally accepted, though?
He argued it should be precluded. He filed a motion to preclude, and that's at appendix pages 39 to 55. It's very detailed as to why that evidence should not have been admitted. He then argued it a second time at another pretrial conference. I think it was the February of 2024 pretrial hearing. And then he again objected to it at trial. So throughout this trial, he fought on the introduction of that. So what I'm getting at here is that when the jury is asked to look at and to assess and to evaluate the credibility of the complainant about the disclosure and about the delay, she's given one side of the story, one tool to look at it from the prosecutors, which is the CSACE evidence, and then they're never told about this other body of evidence out there on suggestibility. So all of these rulings combine.
Let me take you back to the beginning of your presentation this morning, which was, as I recall, you said there were 3 sets of evidentiary errors.
Yes.
That together deprive the defendant of a fair trial.
Independently and then also together.
That's where I'm going.
So,
and you're sure you want to make that argument that each one independently is enough for reversal?
it's an either or an or, right? I mean, the flat out, I think that the CSACE evidence, the admission of that without a Fry hearing is reversible error under Williams and a whole bunch of other cases.
And then
Aren't we,
real quick,
aren't we reversing our own decision though on CSACE? Both department? I mean, this.
You see, the problem with that, embracing that view, is that you've never had a record like this one. No court, to my knowledge, in New York State has ever had a record like this one.
Yeah, but denying the Fry hearing in itself is not reversible error if that court's following people v. Ashton from the fourth department, right?
So Williams, the Court of Appeals in 2020, instructed courts that at the time you are presented with a motion, if you are being told and if there's credible proof that it is not generally accepted within the scientific community, you need to have that hearing. And so Williams reversed on two different types of evidence. It's called LCN, low copy number, and FST, forensic stat tools. Two different categories of evidence. One of them had been admitted for 25 years and in over 140 cases. And the Court of Appeals reversed because the trial judge, when presented with a motion that it was no longer generally accepted, denied the Fry hearing.
Right, but
So-
we, as you argue in your brief on Austin,
Yeah,
you were
yes,
just asked about Austin.
yes, your case, Austin,
Austin, we said, we rejected the what do you say, CSAT, KSAT, whatever you want to call it,
CSAs, yeah.
CSAs. We said there, the record here, we recognized other jurisdictions are going the other way.
Yeah.
We said, where's the fact that the record here does not provide us a basis to conclude otherwise, the record in that case.
Correct.
You're saying we had a totally different record here.
We have a record that
Just
you've
because the
never,
record wasn't sufficient there for us to conclude otherwise,
Exactly.
the record here is different.
I kind of view the Austin opinion as this court inviting the record that was created here. The record there was insufficient, but here there isn't much more that Mr. Burr's trial counsel could have done to establish the record on this issue.
We didn't say in Austin that we disagreed with those other courts from other jurisdictions.
Exactly. You just
You
said
just
you
said-
couldn't do it here.
Give us the right record and we'll take a look at it.
And I
This
think-
is the case he wants to look at.
And I think that Mr. Henry, the trial counsel, did just that. And so whether you look at it as an issue of, Williams or Austin, the Fry hearing is needed here. And then I think that any court reviewing it subsequently will have the full and complete, record. I mean, the people didn't call anyone below, but obviously at a hearing on Fry, they would have the ability to call witnesses. And in fact, it would be their burden to demonstrate that it was generally accepted. So,
I think we understand.
Okay.
Thank you very much.
thank you.
May it please the court, Harmony Healy on behalf of the people. Obviously I'll jump right into the child sexual abuse accommodation syndrome. I have a different reading of Spicola than counsel does. I think that Spicola specifically had information in front of them. The defense counsel did file a motion in the Minute and attached an article and several pieces of information indicating that it was no longer generally accepted in the scientific community. And the Court of Appeals in Spicola said, London and colleagues have reservations about the prevalence of denial and recantation, aspects of CSAS not at issue in this case. Although a substantial portion of children delay reporting or altogether fail to report incidents, there's little evidence to suggest that denials, recantations, and redisclosures are typical when the abused children are asked directly about that during their forensic interview. And the issue in Spicola was a delayed reporting. And so the Court of Appeals here said, the information that you've put forward has challenged the other facets of child sex abuse accommodation syndrome, but is not challenging necessarily directly the delay. And that is exactly what we have here.
Right.
We're using it.
I was reading along with the case that you were reading.
Sure.
And I understand what you're saying. On the other hand, the court is specifically addressing the evidence and the arguments that were made by the defense lawyer in that case. And saying the evidence in this case, there's little evidence to suggest that denials and so forth. The way the counsel looks at it, your opponent is Court of Appeals was just ruling on the evidence there. And that's a long time ago now, but they have other evidence here. So we're not bound by Spicola, is the way they look at it.
So I think that the danger in having a plethora of case law from both the Court of Appeals upholding the reliability of the information and this court and other courts across the state is that every time then a trial attorney marches into all of these lower courts, ignoring all of the other trial court decisions saying that it is scientifically reliable, then you're going to have Fry hearings all the time.
Well, maybe you have one, like we have zero here. Maybe you have one Fry hearing and then everyone lives with it, up or down. They just want one.
And I understand that, but here in this case, I guess to just address the record and the delay issue, the expert in defense counsel's case did indicate that there was empirical data to back up the delay part of the child sex abuse accommodation syndrome. And she was attacking the other facets of it. And I think that that's exactly sort of what happened here. These states, and in the footnote of Spicola, they talk about the fact that other states had declined to use the syndrome and declined to admit it into evidence based on the contradictions between the two competing thoughts on this.
Does it not that neighboring states say this is inadmissible, you're charged over here, and this is like linchpin, well, not linchpin, but this is probative evidence across the border in New York. Like, do we have lesser standards of admissibility here? I guess we do.
So I don't know if it's lesser standards of admissibility. I think that the same issues had been confronted previously before the Court of Appeals, and in this case and others. And this is the same sort of information that has been attacked. This is not a new attack on child sex abuse accommodation syndrome. This is an old attack on child sex abuse accommodation syndrome, and yet case after case.
Have limits on, I mean, and I think just some of, that, it can't be used to corroborate. It's used to explain delay. And in fact, delay isn't just with this syndrome, and it's almost questionable why they even felt they needed this, because it's so well, isn't this kind of recognized delay in reporting of sexual abuse by the legislature, ended the statute of limitations on other sexual abuse and things. I mean, it's pervasive.
So I think perhaps in a legal world and in a statutory world with legislators, we do recognize this because we deal with it so often. But when you're talking about the average juror, it does kind of go against what a person would think. You would think that if you are sexually abused, you would immediately say, hey, I was sexually abused. And this is what is used to explain it. And you're correct, it is not a diagnostic tool. And that is part of the problem with the attacks on the use of the syndrome, is that they are looking at it as though it is a diagnostic tool. And it is very explicitly made throughout this testimony, throughout all the testimony.
Defense here was allowed to call an expert to give a contrary view, right? So it was aired out for the jury.
It was.
It wasn't as though the jury just heard one side and thought nobody challenged it.
Right. And that's exactly why he was not deprived of fair trial, because of the admission of the testimony, because he was able to rebut it and call an expert, and the jury had the ability to weigh both sides of it and determine what they thought was useful in their review of the victim's testimony. And the victim here was very compelling, in my opinion. She was very articulate. This happened at a time when she was, I think, 16, and when she was reporting, she was 16 years old. Defense counsel noted that there were journal entries where she had stated that other people had potentially acted inappropriately towards her, and she didn't really know what happened with her father. Those journal entries were made when she was 11. The reporting happened when she was 16. She was very articulate. She was asked those questions on cross-examination, and the credibility determination should lie within the jury, who had the ability to observe the witness.
All right. We understand your argument. We appreciate your time.
Thank you, Your Honor. Just in light of the fact that there was the amicus brief and I didn't have an opportunity to address it, I would request to do a post-argument submission.
Yeah, you can make an application for that.
Thank you.
Thank you. Case number 367, People versus Little. 367. Good morning, Counselor.
Good morning, Your Honors. Alexander Prieto on behalf of defendant Dejanaya Little. This morning, I'd like to address the appeal waiver and address the youthful offender point. Starting with the appeal waiver, its invalidity stems from the trial court's misstatement of the scope of the issues that would survive the waiver. Trial court told Dejanaya that competency issues would survive the waiver. That's flatly inaccurate. There's one issue, not issues, that survives the waiver, and it's a narrow and discrete issue.
So let me take you back here.
Yes,
This is a 16-year-old defendant.
correct.
So she was 16 when the incident happened, and she was 16 at the time of the plea.
Yes,
And the court asked at the outset of the plea proceeding, do you have a guardian or a parent here? And she says yes. Is there any other inquiry by the court as to the 16-year-old's ability to understand what's happening? Because again, she has no experience in the criminal justice system until this event, correct?
correct.
Is there anything else in the record where the court addresses the child's age or experience or understanding?
No, I don't see anything of that kind. The trial court essentially does this standard sort of colloquy that's normally done, but gets
with
it
a
wrong.
misstatement that you're talking about.
But get it wrong.
But generally, there's no variation in this colloquy by virtue of this defendant being 16. This colloquy could have been used on a 26-year-old or a 36-year-old for that matter.
That's right. The trial court didn't do anything different.
Is there any case law that suggests that court needs to have a different waiver for a younger defendant?
Well, the case law, if we look at Thomas, if we look at all the Court of Appeals cases, has always consistently said that when you're answering the question, the fundamental question for the court is, does this record show with confidence that the defendant understood the nature of the rights being waived? And when the court is answering that question, it looks at the defendant individually. It's not a one-size-fits-all model colloquy. Court has to say, did this defendant understand based on her age, her youth, her experience? All that comes in. So the case law solidly supports that you cannot, the rule is not that the same model colloquy is adequate for all defendants regardless of age or experience.
Right, I mean, that is in the language that's clear, but I think Justice Lindley's question is there a case though that specifically talks about like a 16-year-old? Should have been, that the court should have made this further inquiry. Is there a bright line rule that you're familiar with? I couldn't find.
No, I'm not familiar with a bright line rule. And, in this case, what I've seen, I mean, pretty much since Thomas endorsed the model colloquy, what I've generally seen is the notion, which I don't agree with, in the trial courts, that basically this is okay. You hit the model colloquy, you hit all the points, you get it right. That's enough. That's generally how the trial courts tend to look at it.
One size fits all.
No, it's not a one size fits all. I don't think the Court of Appeals has actually said that in Thomas. And in this case, even if it was a one size fits all, court didn't get it right. The model colloquy actually says this issue of competency to stand trial included if it's relevant to the defendant's case. So even if the court had got it right, it would have been confusing.
All right, let's get to the merits, assuming you get beyond that. YO issues is one of the more brutal assaults we'll see here. 14-year-old girl gets dragged out of a taxi, punch and kick, gets run over by a motor vehicle. Which your client was in, a partial video of it gets posted on Instagram, hospitalized for a long period of time, major injuries. This was just not a fist fight. This was the victim lucky to have survived this one, honestly.
It is undoubtedly a brutal assault, Your Honor, and I recognize that. I recognize that these facts are very sad, very troubling, very concerning. And I recognize that in light of those facts, to persuade this court that a youthful offender finding is warranted, I have to come with a very strong case on all the rest of the factors, but I believe that I've done that. It's notable here that the people did not present any argument on any of the other 9 factors. That's reflective of the fact that if we get beyond the facts of this assault, which really were an aberration, Deja Naya is exactly the kind of person that the youthful offender statute was meant for.
The assault publication of it too, so it's not right. I mean, isn't that a problem?
There's no, I mean, there is
It's like showing, I mean, because one could argue, wow, this was a friend and she, felt bad about it, but she didn't really feel bad about it. She promoted it.
we don't know who, as far as my reading the record, there's a mention of something being posted, either Facebook, Instagram, something like that. But there's just something that a crime that was committed by multiple girls, and we don't have evidence of who did that.
One of the reasons we don't know who these other girls were, who exactly was driving the car. Our victim thinks it was your client who drove over behind the wheel. But if your client had cooperated with the police and admitted wrongdoing, but it sounds like she was silent to protect all these other people who were involved in the assault as well. That doesn't seem to be somebody who's worthy of leniency.
She was not protecting other people involved in my reading of the record. According to the defense counsel's statement at the sentencing hearing, she offered to help and identify others involved, but the prosecution wasn't interested.
I'm talking about like at the time, nobody else was arrested on this, I don't think, right?
Not that I'm aware of, no.
She knew who all her friends were that almost killed this woman. And yet, now don't get me wrong, she's got no obligation. She has the right to remain silent. She has no obligation to cooperate with law, nothing. But it's a factor to consider if somebody cooperates. And she knows who was driving that car if it wasn't her. She knows who beat that girl almost to death.
But
She said nothing.
there are other factors. We have to look at, this is a holistic analysis. Deja Naya had no prior criminal record of any kind, no disciplinary record at school. She is a bright, talented girl who rose above a troubled background to succeed academically, to shine as a musician. The School of the Arts where she attended is one of the most prestigious, if not the most prestigious public school in the city school system here in Rochester. It has a competitive audition process. She was regarded by her teachers there as someone who cared about her peers.
Did the court
could help
take
them.
that into account that she did receive close to a minimum sentence, though, didn't she?
Well, the court really focused on the facts of the offense. It said that it had considered every factor, but we don't get a detailed YO analysis from the court. So, but obviously, when we look at Deja Naya's background, she was thrown badly off course. And that brings me to the second point that I want to emphasize here, which is that the developments that led to her involvement in this incident, those happened during the early part of the COVID-19 pandemic. And I think to really understand this case, we do need to try to take a step back in time and try to remember just how uncertain, how chaotic, how truly frightening at times those times were. I can say for myself, as an adult with a strong support system, it was hard enough. But Deja Naya had to get through them as an adolescent dealing with untreated mental health issues, living in a community with fewer resources than many. We have a generation of kids now who were impacted, some like Deja Naya, badly impacted by growing up during the pandemic. And their cases, if they've been involved with the criminal justice system, their cases are just going to be coming up to appeal to this court. And I submit that it's appropriate when the court is considering, is it in the best interest of society for Deja Naya to get the fresh start a youthful offender finding would entail? The court should look at the fact that she is already burdened by having the misfortune to be born at a time when her formative early adolescent years
And look, you're
were
making a
dominated by fear and isolation.
A very eloquent case for her, as you did in your brief, and we understand she's already served some time here. So if she already get YO now, it's not like she's not being punished. So we're gonna take a close look at all that, and we thank you for your representation.
Thank you.
May it please the court, Bridget Field on behalf of the people. I believe the waiver was appropriate in this case.
So, I mean, you would agree that when you, just in reviewing the record, it looks like the court sort of, for lack of a better word, followed the script
Yes,
with the 16-year-old.
correct.
Didn't deviate in any way.
Correct.
What we would, and that would be sufficient to draw some kind of determination that the 16-year-old understands the nature of what's happening at this proceeding and is voluntarily in.
I would agree. And certainly nobody's questioning this Miss Little's ability to enter the plea in this case. And the plea followed basically a script.
If we think that defendants of any age are listening carefully and understanding every word of that waiver colloquy, I think we are deluded. We're hoping that their lawyers are explaining the nature of the waiver before they get into court, but the court does have to read it. But I'm not sure if you put any defendant under oath, they would be able to explain what was just said during the waiver colloquy. But in any event, you're saying there's no requirement that they have to tailor it to a younger defendant. And how about the merits of the YO?
There is not, and I would stress that Ms.
People, B. Thomas, say that you have to make sure you have to do something further to make sure that the person understands the rights and the distinctions that they're dealing with.
There's not, first of all, Miss Little was in fact represented by counsel who raised no objections, didn't ask for any time to discuss the matter. She didn't ask to discuss anything with her attorney. And no, there is no case law indicating that the court had to go farther.
Was there a written waiver here? I forget.
Pardon?
Was there a written waiver here?
There was I believe there was a written waiver that followed the model colloquy. The written waiver was one of the newer, I would call it a newer waiver used by our office, and it is one that has been upheld by this court. in previous cases. So it was a detailed waiver, and that's my recollection of the record at this point. And if moving on to the WIO status, this was a horrific crime. And this was a very advantageous plea agreement in this case. And the judge, in pronouncing sentence and in denying WIO, noted that she had reviewed the grand jury minutes, the police reports, the motions, the pre-plea investigation, counsel's mitigation report, mitigation factors that had been given to the court. So the court did stress her review of many documents and information prior to declining to adjudicate this young woman a youthful offender. Certainly there are factors that go in her favor. However, the crime was really, really very, very bad in this case. It was a horrible beating. The young lady, the 14-year-old girl that was attacked, had very, very serious injuries. And the information in the police reports and other documents indicate not only was she beaten, they got in the car and then ran over her. This was very, very severe. This crime did not, under the circumstances of this case, it was appropriate that the judge declined to adjudicate Ms. Little a WIO offender in this case.
All right, thank you very much.
Thank you.
Case number 368 is People versus Michael Relier. 368 Relier. Mr. King, good morning again.
Good morning again. May it please the court. Brad Keem for Mr. Relier. In the brief, we outlined the alleged violations of probation. We maintain that the ones the people did establish are still de minimis in nature, and that the court should return Michael to probation where he can continue making the legitimate rehabilitative progress that he was making, and that is outlined in that point and our harsh and excessive sentence point. Unless there are questions on that issue or any of the others raised in the brief, we will rely on it.
Right. We thank you. Case number 369, Buffalo City Cemetery versus Netherlands Insurance Company. Good morning. Counsel for the appellant, Mr. Potashner, is virtual. We're waiting for him to log on. And there he is now. Counsel, you may proceed.
Thank you. May it please the court, Marshall Potashner for Netherlands Insurance Company. The key fact here is that Netherlands is continuing to provide a complete defense to the Buffalo City Cemetery. There's no claim that the cemetery has paid or is responsible for paying any monies toward the defense. And there's no substantive difference between this situation and where an insurer defends under a reservation of rights.
Right. Let me just stop you there. I think your argument is that there's no legal controversy. There's no rights to declare because the duty to defend is being honored, has been honored for years and years. There's no intention not to honor it. And if we were just concerned with the duty to defend, I might be inclined to agree. But your disclaimer letter, your carrier first reserved rights regarding indemnification. Then we get the second one that provides, they disclaim coverage. They say, we're going to provide you a courtesy defense, but we're disclaiming coverage. There's no coverage here. Is that different? Because now we have a change in the coverage status so that the insured is being told, whatever happens with that underlying lawsuit, any of those claims, if you get hit with a judgment, you are not covered. They say that's at issue now, and that's why this is ripe for adjudication.
Well, on a duty to indemnify, the reason why it's not, and I will get to the substantive issues as to whether it's coverage, it's an alternative argument.
Right.
Duty to indemnify. It's still premature because we don't know on what basis there will be liability. And
I get that. And you cite all those cases, and the Court of Appeals cases do say what you say, but here you're saying your carrier said under no circumstances are we going to indemnify you for any of the claims. The Court of Appeals says the duty to indemnify, we have to wait to see what the claims are and what happens at trial and what the finding of liability is. Here you have a carrier saying, we don't care any of those claims in that complaint, the underlying complaint, class action, not covered. So they say that's why we don't have to wait here.
Well, Your Honor, I mean, to be fair, what the insurance company was doing based upon the information is developed, and I'll get to the substantive in a second.
Sure.
Information was developed saying that we don't think, we're just being upfront, we don't think there's any coverage here. And the thing is, if you were to rule on a duty to indemnify, it would be a what if ruling. Well, if they're liable on this issue, then there's coverage. If they're liable on this issue, there's no coverage. And that's the problem here. That's why this should have waited until there's a determination on this underlying case, which may end up being, it could end up being that there's damages here, but no damages there. There could be a finding based upon the intentional infliction of emotional distress. We don't know. But
let's go back. Let's go back for a moment to the defense obligation. Under the contract, if there is coverage, or if arguably there's coverage here, the contractual obligation is to defend, not provide a courtesy defense. That's not what they got in exchange for the premium, and that's what you're proposing as an equivalent as a defense, is this courtesy position.
But it doesn't really change anything. I mean, they're still getting paid. They're controlling the defense like you would whenever there's a reservation rights. They pick counsel, and their counsel is being paid by Netherlands. But let's go to the substance of I'd like to address the substance of the argument.
Yeah, right before you do that, let me just say this. If your client is confident in their disclaimer on the substance, which you're about to talk about, if they feel good about their disclaimer, why don't they want us or the trial court to look at the merits of their disclaimer?
We do.
I thought you said that this is not ripe and it should be dismissed.
Well, the alternative argument, it should be dismissed because there is no potential duty to defend.
Right. Your first argument is that we should dismiss it because it's not ripe yet. There's no legal controversy. Second argument is that if it is, let's get to the merits. But what I'm saying is that it would seem like everybody, you would welcome eyes on this now. And it seems like you don't want eyes on it. You're not you, but the client doesn't want anyone to look at the merits of their disclaimer yet. Let's get to that later.
No, well, originally the thinking was, this is an insured. It wasn't, it's kind of a novel issue. There's not a lot of case law in it. Let's protect them and see what happens. But since they raised the issue, we do want to address the merits. They brought this into court to address the merits.
Okay.
And here you got no covered claims alleged. The definition of bodily injury in the policy requires physical injury for emotional distress damages. The cemetery does not dispute that if the definition governs. Now let's talk about where the definition is. As the policy states on pages at the record 348 for the first policy and 707, words and phrases that appear in quotation marks have special meaning refer to Section 5 definitions. Then you go to page, for example, on the record, page 238. That's a definition. And by the way, the interesting thing about it, before the definition, it changes the definition from the main coverage form, and it says, quote, under Section 5-definitions, definition 3 is replaced by the following. Then it gives a definition of bodily injury that requires physical harm for emotional distress coverage. Of note, throughout the policy, whenever there's a change of a definition or a change of another form, like another situation like that, there is a preface which says, we are changing this, this now governs. That's not here in the funeral.
Right, counsel, let me ask you this. So in your brief, and I agree, I think everyone agrees in the main body of the policy, there's coverage for physical injury or property damage. The claims in the Robinson case have neither. They're all emotional distress, mental anguish. In the main body of the policy, what they are relying on, though, the insurer is relying on the cemetery endorsement. The endorsement that they paid extra for. They say you didn't even mention that in your brief. But the cemetery endorsement says, and I'm just going off the top of my head here, but it provides recovery for bodily injury, including mental anguish. So they say, reading that, if it's ambiguous in their favor, mental anguish is covered by the endorsement, not in the body. That's their argument.
Okay, no, I know that. I was going to get to that, and I did address it in the court below the funeral and cemeteries endorsement. When you look at the endorsement, first of all, you got paragraph A. It does not expand the definition of bodily injury. In fact, the term bodily injury there is in quotes to show that that's what it means. Then it says including. Then you read the rest of the sentence, and it's not intending to expand the definition of bodily injury. It's addressing what's deemed to be an occurrence and how many occurrences there are. In fact, if you take a look and you go down to the next section that talks about damages the insured is legally obligated to pay, and what that does is that addresses an exclusion, because there's an exclusion in the policy for property of others in the custody, control, care or control of the insured. That's just saying that exclusion doesn't apply. But then when you go down to paragraph C, and I think this is important too.
Okay.
Paragraph C, and again, I'm looking at the record 347, is an exclusion. It says this insurance does not apply to, it says bodily injury in quotes, or property damage due to. And then one of the things is mental anguish that or of an employee, and it goes on. I'm not saying that applies here, but the fact that they're talking about, they don't say bodily injury including mental anguish. They're saying we only provide coverage for bodily injury or property damage, and there's an exclusion for mental anguish to the extent it falls within the definition of bodily injury for this type of situation.
All right, that's a legitimate point. That's a good point, and we'll take a look at that.
And
Let me ask you this. Can I ask you this question? Is it your view that the cemetery endorsement, would you agree they paid extra for that? They paid extra for the endorsement? The insured did? All right, well, you don't have to answer now, but they say they did. But let's say your position is that, and we agree, I think everyone agrees that the main policy does not provide coverage for mental anguish. It's bodily injury or property damage. The plaintiffs in the Robinson case have neither. If the endorsement, so your view is that that cemetery endorsement provides no extra coverage than that which is provided in the main policy?
No, my view is what it does is it negates the care, custody, control exclusion, and it defines what is an occurrence. Because if you read the whole sentence is bodily injury, including mental anguish or property damage arising out of the rendering or failure to render professional services as a funeral director, embalmer, or intern while you are doing business as a cemetery, shall be deemed to be caused by an occurrence. Because normally professional services would not be considered an occurrence. So this addresses what's an occurrence. Is you got to read the whole sentence. You can't just read the first phrase.
Right. So it does provide more coverage than the main policy.
Yes, and then it negates that exclusion, but then adds another exclusion. And as far as of note, this endorsement doesn't have an insuring agreement. It doesn't have a duty to defend. You still got to go back to the insuring agreement, and you go back to the insuring agreement, which says when there's coverage, what we do, what we defend, and we pay. It uses the term bodily injury solely in the quotes. It doesn't use the term bodily injury, including mental anguish. So what they're trying to do is take this to amend a different provision of the policy, which there's nothing indicating that this amends that base insuring agreement that says when you have a duty to defend and when you have a duty to pay. What this does is it defines how you treat occurrences and negates that one exclusion to allow.
Why is Netherlands continuing to defend for 5-6 years at millions of dollars if there's no coverage? Why the courtesy defense?
Well, obviously we have this. There's two reasons. One, this client actually does sometimes protect insureds when it's not the clearest legal issue, because the courts really The New York.
Right. It's a little ambiguous. The policy is a little
I'm not
ambiguous.
saying it's ambiguous at all. I'm not saying it's ambiguous at all. What I'm saying is insurance companies do this all the time for business reasons, for numerous reasons. Maybe they don't feel like getting into litigation over it. And by the way, the class action was I believe rejected here in the underlying case, so it's just a single case.
Counselor, I have to take you back to something. I'm probably way behind the conversation here, and I'm sorry. But I know that the Court of Appeals late last year, in a case called San Miguel, outlined the three situations, the narrow instances where New York recognizes where a plaintiff may recover for emotional suffering absent physical injury. One of those is well known and dates back probably 50 years in New York at least. That is where there has been a mishandling of a family member's remains, and it's sometimes called the right of sepulcher. The way I read that cemetery endorsement, it's clearly designed to cover for that, because if anybody's going to get sued for that, first and foremost, will be funeral directors or cemeteries. So it seems to me that that endorsement is clearly designed to cover that emotional suffering damage claim, even in the absence of physical injury. Do you agree?
No, Your Honor. I believe, what year did you say that case came down?
2025, late last year.
Yeah, so this endorsement and these policies predate that. And this is the endorsements.
Well, time out. Let's not go down that path. It's not like they recognize something new. If you look at the cases called Lando, Lando from 1976, and from Johnson versus State from 1975, New York has recognized that right for 50 years, at least.
Yeah, but if that was the intent, then there would have been a definitional change of bodily injury, like they did, because the original policy would have covered, if you look at the coverage form, all emotional distress under the Lavina case. Then they have this endorsement that was added that narrowed the definition of bodily injury. And it narrows it by saying, we are changing the definition of bodily injury to this. If that was the intent of this endorsement would say, we are changing the definition of bodily injury to this. But it doesn't say that. It doesn't say bodily injury and mental anguish. Mental anguish, a certain type of mental anguish, not the type here, does fall within the definition of bodily injury. So when they're saying bodily injury, including mental anguish, the use of the word including, they're saying we're talking about the mental anguish that's within the definition of bodily injury. And
right, or as a result of, if you suffer anguish as a result of a bodily injury, that's covered, not just standalone mental anguish, is your point.
Yes. And what this sentence really does is when you go through the rest of the sentence, it's not talking about what is bodily injury, the type of damages that's covered. It's talking about what's an occurrence. And it's negating the ability of the insurance company to say, wait a second, what you're doing is a professional services, and that's not covered under a CGL policy. That's covered under E&O policy. And that's what the purpose of this endorsement, not to expand the definition of bodily injury. Because again, if it did, it would make no sense given the insuring agreements, which are in different parts of the policy, which do not have including mental anguish. It just says we defend bodily injury and property damage. We pay for bodily injury, property damage. No mental anguish is alleged there. So our position is what this endorsement does, it doesn't change the base definitions, which, as the court notes, is particularly clear. Just to go two quick other points. One, the attorney's fees for prosecuting this case. I don't see that wasn't even posed below for some reason. Right. Still denied our motion. And
right, and there's no basis for punitives. It's not even worth arguing, honestly.
Okay. Yes, thank you, Your Honor. So unless Your Honors have any further questions, I'll rest on my briefs.
Thank you so much.
May it please the court, Mark Delaposta on behalf of Buffalo City Cemeteries. First of all, Your Honor, which has not been discussed today, but I think it's probably the most important point, is this is a 3211 motion to dismiss. Court of Appeals has said you look within the four corners of the complaint. If you can find any cognizable claim or claims under the liberal pleading standards of New York State, then the motion is denied. The motion was denied here for that reason and others. This is not a summary judgment motion. We're looking to identify certain issues or for judgment on certain issues. Now, the issue of ripeness, which was discussed, the 2020 reservation of rights letter, when you compare it to the 2024 disclaimer letter, are two very widely
If they
different
had kept the
documents.
reservation of rights letter, then it would not be ripe. You
Correct.
can't
If we
bring
were
any
here with
DJ
the
action.
2020 letter, it would not be right.
Right, but this is different because this is a disclaimer. They're not reserving anymore. They have made up their mind and they're saying no coverage for indemnification.
They've made up their mind based upon no new evidence. No discovery took place in the underlying action in those 3+ years. There's nothing new. It's the policy and the complaint. They analyzed it in 2020, said, well, there are claims, some of them may be covered, some of them maybe not. We'll reserve our right. Go ahead and defend the case. 3 years later, the only thing that's changed is we canceled the policy going forward, and they decided, well, we're going to cancel the coverage on this. We're going to disclaim coverage. We're going to give you a courtesy defense, but we're going to disclaim coverage. So they already made that determination, as you noted, Judge Lynn.
How about we get to the merits of the policy dispute, the coverage dispute?
So in terms of the disclaimer versus the reservation of rights, it's really interesting to note that in the reservation of rights letter in 2020, they analyzed this endorsement, the funeral and cemetery endorsement, and that was in part why they came up with this fact that some are covered, some are not covered. In the 2024 letter, they mention it, they list it as a policy provision. There's no analysis, no explanation whatsoever as to why this is not covered. Anything that Mr. Potashner is saying today is not included in that letter about that exclusion. That's improper. Now, if you look at the exclusion, if you look in the endorsement, it says the provisions of this policy apply unless modified by the endorsement. They are modified, as Judge Curran pointed out. Bodily injury, including mental anguish. Why did they put in the words including mental anguish? There's no need to with the original definition if that's what you're going on. Instead, they modify the definition.
Do you think, you're not suggesting mental anguish is bodily injury because it comes from the brain's part of the body?
No, because that's not how they define it originally.
Gotcha.
And the reason why they did that is, as Justice Curran said, the right of sepulcher. It's the fourth cause of action that's pled here. And it says specifically that the likelihood of emotional injury, this is in Shipley versus City of New York, is deemed so inherently genuine in such cases that neither proof of the plaintiff's accompanying physical harm nor of a specific medical diagnosis and course of treatment is essential to a successful prosecution of the claim. So if this endorsement, this funeral and cemetery endorsement, is not for a right of sepulcher, what is it for?
Did your client pay extra for that?
Yes.
So you're saying they must have gotten some extra coverage, and this is what
Yes.
the extra coverage is.
And that word including medical, the phrase including mental anguish, if you take their position, there's no reason for that word. Words have consequences, and policy terms are to be liberally construed in favor of the insured. So on that, I don't know what else you could use that funeral homes and cemeteries exclusion, but for a type of right of sepulcher.
If it were to be ambiguous, you win anyways?
Yes.
Attorney's fees, would you concede that there's no basis?
You can see there's no basis for attorneys.
How about punitives?
I think it's still an open question, Your Honor.
We're not talking about punitives in the underlying action, Robinson. We're talking about punitives in this case.
Yes.
You're saying this is so wanted and egregious that they're providing a courtesy defense that you're entitled to punitive.
Yes, because what is the reason why 3 years later they changed the standard?
I'm not defending. I mean, we could say that it was a wrongful disclaimer without. I mean, punitives is.
You could, but we've alleged in the complaint that there was a reason for it, that they were retaliatory against us because we canceled the policy.
This is a breach of contract case, basically, right?
I'm sorry?
I'm sorry. This is a breach of contract case. Correct.
The second cause of action is breach of contract.
Primarily, that's what this is. You don't get punitive damages there, right?
Correct. But the Unfair Claim Practices Act, bad faith in adjusting this. And if you look at the brief itself, they cite this case of Reed versus Netherlands. It's a federal court district case, 2015. Same policy, same funeral endorsement against Netherlands. So it's the same defendant. And in that case, if you read the decision, which, by the way, in the record, it says the decision is attached. It's not the decision. It's the memorandum submitted by Netherlands. The decision can be found at 860 Fed F sub second 407. But if you read that, it says plaintiff's theory of recovery is under the endorsement. There's a coverage for bodily injury, including mental anguish arising from cemeteries' failure to provide professional services. Netherlands says these claims are barred because plaintiff did not discover an alleged error until March 11, 2009. So they decided in that court, and that the judge decided there's no coverage because, not because of what they are saying, it was because the policy had expired before the mental anguish was felt or experienced by the plaintiff. They're citing it as if that supports their position here. It does not support their position here, but what it does is give me further evidence that they're treating this in bad faith. They're citing cases that are improperly cited to this case.
Is the Robinson case anywhere close to being resolved?
I'm sorry?
Is the Robinson case anywhere close?
No, it's my understanding, as Mr. Petashner said, that the class certification was denied and that may be on its way up on an appeal. So I'm not involved in the underlying case, but
So
it's my
technically,
understanding there's
your
no.
client, because the duty to defend has been honored, albeit in a courtesy fashion. Indemnification, your client hasn't had to pay anybody.
They haven't yet, but they've already just.
But I guess you're saying your client is so concerned about this disclaimer that they might not have coverage, that therefore they're entitled to punitive. Like, this is so egregious.
Yes, and it's, they can withdraw it at any time. They specifically say that, at any time. It isn't like.
Right, but the reservation of rights letter said the exact same thing.
Doesn't say the exact same thing. It doesn't say at any time. It says, we will look at it, we will see what comes in, and we'll reserve our right to disclaim. Here, nothing new is coming in, and now they're disclaiming. So what does that tell you about how they're treating this claim?
We'll take a close look at it. We thank you.
Thank you, Ron.
Case number 371 is Newton versus Vancheri. Good afternoon, Mr. Weber. You may proceed.
Good afternoon, Your Honor. May it please the court, Corey Weber for defendants Vancheri, Kraus, and Venti.
Just before you go further, I haven't forgotten Mr. Haju, who's on remote. We skipped over him. We're going to get to him in a moment. You will take care of your case first.
Thank you, Your Honor. This case comes down to the question of whether there is a threshold time frame when the causal link between a violation of Vehicle and Traffic Law 1210 and a subsequent accident breaks the chain of causation. It's our position that the courts who have addressed similar timeframes as are involved in this case have all come down to say somewhere around 2 and 3 days is a sufficient time.
We're at 2 days here.
On the face of the complaint, it alleges that it's 2 days. The plaintiff in their opposition actually provided some more information that shows it's into the 3rd day between the
2+.
So yes, we're at 2+ now. And based on the cases that have ruled on this, we believe that we're beyond that threshold. So on the face of the complaint, it should have been dismissed, and the cases cited by the plaintiff in opposition involved different scenarios. One of them involved an accident that occurred while a bus was being stolen and had gone half a mile down the block.
Right. So we're going to take a look at all those cases. I know both sides cited a lot of them. We will do that.
Thank you, Your Honor. Unless there are any questions, we can rest on our brief.
Thank you so much.
Thank you.
Good afternoon, Your Honors. May it please the court. Adam Delabovi for respondent, Ramon Newton. Your Honors, this matter comes to you on a motion to dismiss, not a motion for summary judgment. The standard here is that we look at the complaint, we accept all facts as alleged as true, and we look at whether those facts fit within a legal theory. Here, as the lower court decided, the respondent did allege negligence, violations of the Vehicle and Traffic Law. That negligence was a cause of the accident, and the respondent was injured. That is a negligence cause of action. The arguments put forth by the appellant is focused on causation. Those arguments are for a jury to decide. It's not within the scope of this motion. And I would just like to add in closing that the cases relied upon by the appellants all of those cases were decided on a summary judgment posture, not a motion to dismiss.
Right. Well, thank you very much.
Thank you.
Case number 370 is Richard F. Mills versus Wolcott, Superintendent of Attica Correctional Facility. 370. Council is remote. There he is, all right.
Good morning.
Good afternoon. I apologize for skipping you over there. My fault.
That's fine, Your Honor. May it please the court, Lyle Hoydu, representing Richard Mills. Mr. Mills is an inmate in state prison. He's serving a sentence of 20 years to life. He filed a pro se petition for a writ of habeas corpus. And within the body of his petition, he does allege he challenges the jurisdiction of the court. So he should be entitled to the writ. We think it was an error for the judge to summarily deny it, implying that he had to raise these issues on either direct appeal or a 440 motion. And as the court's aware, challenges to jurisdiction are never waived. So for that reason, we would ask that the matter be remitted, that the writ be issued, and also that a counsel be assigned to represent him.
All right. Thank you so kindly. Take a look at that. Case number 372, Hurst versus State of New York. Good afternoon.
Good afternoon, Your Honors. May it please the court. My name is Chris Borgatti. I'm with the appellate, the claimants, Stephanie and Ryland Hurst. This case comes to you after a Court of Claims trial, and there's two issues before the court today. First is whether general obligations law, section 9103, provides immunity to the defendant, New York State. The second is whether the assumption of risk doctrine applies to the facts here. The claimant's position remains that neither applies, and that we ask this court to reverse the lower court.
For the assumption of risk, I think you would acknowledge sledding, people assume the risk of that activity, but they don't, your argument would be they don't assume the added risk of a snowbank at the end of the run that served as a launching pad. That's what differentiates this from other sledding cases.
That's exactly correct. I think there's also another fact about the terrain of the hill, with its location where they've constructed a traffic circle with, right where you would run out of your sled. So there's a shorter distance on that side of the hill.
Right. There was some claim that I didn't follow exactly about how they maintained the hill. They mowed the grass so it pushed people to the left. Is that part of it?
So the hill in question here serves mainly as a wall for the reservoir park at the Power Authority. And part of that hill was not cut back, so it was allowed to grow. This is the steeper section of the hill that we're talking about. And at some point, we don't have exact dates of when this happened, but that part of the hill was cut back. The defendant cuts the grass twice a year over that. And for some reason, it was cut there, which allowed access to sledders in the winter to access that.
There's no supervision there. There's no park, right? There's no group of people that work there to facilitate sledding, right?
Well, the short answer is there is not someone that directly oversees supervision of sledding at the park.
Right. And the other thing that isn't the burden you have here that well, basically for us to reverse that, we would have to find that it's obvious that the court's ruling could not be reached under any fair interpretation. That's the standard.
I believe that's the standard.
So how do we get to that? So I mean, so theoretically we could agree with, yours is a better argument, but it almost has to be essentially an egregious.
Well, I think in this case, it's important to note that the affirmative defense of general obligations law that provides immunity was not raised in the answer, was not raised in the vote particulars, was not raised at trial. The first time it was raised in this case was in the post-trial submission by the defendant, which, if I understand the Court of Claims correctly, there's discretion on whether to allow a reply brief. There was no schedule for a reply brief in the lower court to even decide this issue. So the first time it came to us was right now. It's on appeal. So we weren't able to argue at the lower court this because it was not brought to us.
And you do address the Ferris case in the Court of Appeals there?
I think that's to Justice Greenwood's point about supervision. The standard really isn't whether or not somebody was actually watching it. The standard that gets it out of general obligations law is the supervised park exception. That I believe that Reservoir Park, in our brief, we talk about all the different facts that put it in line with the Ferris case.
Status as a government entity also. And what drew my attention in the Ferris case, and I'm not sure what to make of just yet, where the Court of Appeal says, well, this is clearly not the case when someone is injured in a city park, like the one here, where the public is already encouraged to engage in recreational activities of all kinds. If I understood your argument, essentially that's what the state essentially did here by putting on its website that sledding was encouraged. So do I have it right that that's how you're distinguishing Ferris among others, as opposed to the supervision in the park? You're saying that when you put it on your website, you're inviting people to come in. It's not the same that this is designed for this statute in any event.
Correct. And that's precisely the argument in Ferris that's made. And the distinction it draws, which is really the interesting part of Ferris, is that it outlines the legislative intent and the spirit of the law. And that when you get to that point, that Ferris says, I think you have to look exactly to Ferris to make the answer here.
It seems like the intent was, if somebody's using your land for recreation, and you just let them do it, you shouldn't be sued if something goes wrong. We want to encourage people to let other people, we don't want to say, get off my land type thing. This is, the government was saying, please come onto our land and use this for all these different type of recreational activities. So it just doesn't fit within the spirit. I think we understand your argument. Any last words?
No, I think, just looking through my argument here, I think if the court has any other questions, I think I'll rest on my brief.
Thank you.
It addresses everything. Thank you.
Good afternoon, Your Honor. Your Honor, is William Hayes on behalf of the state. The Court of Claims judgment dismissing the claim should be affirmed on either of two independent grounds, both of which are based on a fair interpretation of the evidence admitted.
So if we found that it was a little bit unfair to invoke the GOL, and the way the court addressed it, whether or not that was fair to bring it up on appeal, things like that, and whether or not Ferris means what it says in that one sentence, you would say, nevertheless, assumption of the risk is enough?
Yes, assumption of risk is a
What about the
complete
counter argument that the presiding justice here mentioned, that is that the slope at the end is where you increase the risk, and that's why you don't get the benefit of the assumption of risk doctrine?
Sure. So with respect to, whether claimant assumed the precise risk associated with going over the snowbank, it's enough that it was reasonably foreseeable, and claimant's actions before the day of the accident and on the day of the accident reflect that it was. So claimant testified that she had been to Reservoir State Park to sled specifically about 10 times before, including with her children.
She did a test run, as did her husband.
Yeah.
And they didn't make it down. I take it that the snowplow pushed the snow onto the yard, and then the mother and her child came down the slope, went up in the air, hit the snowbank, and she landed on her head onto concrete. Is that an open and obvious, like the first two runs, they didn't come anywhere near that. But you're saying they should have been aware of that risk anyways.
Yes, for a few different reasons. So as to the snowbanks themselves, the Court of Claims found that these were open and were clearly there for her to see, open and obvious conditions. I believe Mr. Hurst testified at his deposition that they were about 2 feet tall. So they're not concealed. They're not like unusual. As to the specific risk that she would hit them, some of the risks that are inherent in sledding are the risks that you might go too fast. That's reflected in the test run that she took down the hill.
You would argue that the risk is there to be seen.
Correct. Even if she didn't, subjectively predict that she would encounter the snowbanks, this is just encompassed within the risk.
Her husband told her, you might want to slow down with using your feet, and she did not do that.
Correct. So she understood, both of them understood that, a hill might be faster than you anticipate, And before you go down with your child, where you're even more limited in your steering, you might want to understand, you know, how the hill is running that day. And again, you know, the cases recognize that there are just certain risks, that you might encounter an object, that you might fall off your sled, that you might go airborne after encountering an object. Those are all inherent in sledding, and participants in sledding assume those risks. So if there are any other questions on assumption of risk, I'm happy to address the recreational use statute. I mean, if there are questions on that.
Yeah, I think I think you briefed that really thoroughly.
Okay.
And if you went on the first one, we don't even get to that one.
Right. And just a couple of quick responses. The Ferris case says that this is not actually an affirmative defense that needs to be pleaded in an answer. And again, as we outlined in the brief, there are two different grounds in which we think that the Ferris exception does not help claimants here.
Thank you, Counsel.
Thank you.
Case number 375 is Partnership for the Public Good versus City of Buffalo and others.
Good afternoon, Your Honors. May it please the court. Matthew Parham from the Western New York Law Center on behalf of the appellants. In 2020, Buffalo's Common Council enacted a proactive rental inspections law following decades of advocacy by community members and organizations seeking a solution to pervasive substandard conditions in rental housing in Buffalo.
We're very familiar with the facts, as I'm sure you can appreciate after being here most of the day.
Thank you, Your Honor.
See, here's the question I've got.
Yes, Your Honor.
Really whether or not this fits mandamus. That's what it comes down to for me. And if it's discretionary in any respect, then you can't get mandamus. Do I have the law close?
Well, let me somewhat correct that. I mean, Your Honor might have exactly what the law is in mind, but there may be some imprecision in the statement.
Cases that I have here, but is that
the city has an argument basically that if there's discretion in how you perform a duty, the duty itself is discretionary, and that is a distinction that the Court of Appeals has made. So the fact that there's some discretion in, say, the timing of inspections and how long they happen,
or whether to do them at all. The commissioner said, "I'm not doing any inspections."
That's not discretionary under this law, Your Honor, and that's the distinction. So that, you know,
that would be clearly subject of mandamus, right? If she refuses to do it, I'm not going to do any inspections.
Correct, Your Honor. And our position is they're not doing the inspections required by the law. And this is a proactive rental inspections law.
Type of inspection? Is that your argument?
No, Your Honor. I suppose you could say proactive versus reactive. I mean, what they're doing.
Is it the type? Is it the number? Because they're clearly doing inspections. You would allege that, you don't dispute that, they're clearly doing inspections. And, you know, for a good purpose. Lead paint, you know, the courts are well familiar with those cases. So, but they're doing inspections, so I'm trying to figure out how it is that they are, is it that is they're not doing enough? Do they have to do 100%? Is your argument that 85% is enough? If that's your argument, you see the problem with it.
Well, the law, so at section 264-8, subsection A, it provides that the commissioner shall inspect, it uses mandatory language, every property that is the subject of an application for a license under the chapter. And a license under the chapter is, I can address this if the court wants, but it clearly includes an application for rental registration or renewal. So there are 36,000 properties in the rental registry that
what if they inspect 35,999? Can you get mandamus for the one?
So, Your Honor, I would say no. So I think that maybe we're coming together now.
Agree on your argument, or is it a categorical?
So we would take the position. So the Court of Appeals has talked about whether there's substantial compliance and whether the city has exceeded its discretion and whether it undermines the central purpose of the law. This is in some of the cases on timing that we address that we cite in our brief. So yes, if you had 35,999 inspected and not the 36,000. We wouldn't be here, and there would be, I think, no argument that
how many is enough?
There has to be substantial compliance, Your Honor. So
I mean, 14% now of the 36,000 have been inspected as of the writing of the brief. Maybe a little higher.
Roughly 17. I think Your Honor is in the ballpark. Yes,
17
over 5 years. So I mean, this is always intended to be a triennial repeating.
Under the law, all 36,000 are supposed to be within 3 years.
Correct.
And they say we don't have enough staff. We don't have. They want the county, the state. You say 14, 17, whatever it is, it isn't enough.
And not having enough staff is not
where does it become enough? I really think it's Justice Kern's question. Like, when do we say there is compliance? 30, 40, 50, 80, 90? I mean, it seems kind of arbitrary.
So I think the intention when this law was passed, because the law has essentially two inspection requirements, one upon registration and one as part of the CRC process, which is the triennial certificate that landlords are also required to get. And the intention was there would be an initial round of inspections of everything that's in the registry, and then after that, the CRC process would take over. They'd be roughly triennial. So if they were moving towards that, if they were doing a third a year, which is what this ultimately contemplates, we would not be here.
Statute, a third year is not the statute.
I mean, the statute, they're violating the statute. The question is, would we be entitled to mandamus for the violation?
See, you know, it's almost like when you come to us on a mandamus, you have to design the order you want.
Yes,
And then you
Your
have to prepare to defend it.
The order we want is one that would say they have to come into compliance and give a timeline for coming into compliance. They're way out of compliance.
How would we come up with that timeline, and what number would we come up with if we end? What if, I mean, are we supposed to then say a drive-by is good enough?
Well, that's an interior inspection under the ordinance.
Does the law say that?
Yes.
Okay, so you have to go in the interior. If you cross the threshold, is that sufficient?
I mean, that'd be a different case, Your Honor. It probably wouldn't be, because it requires various things to be checked
I'm going to
specifically.
be intellectually honest with you. You see where I'm going with my concern about mandamus here, drawing the line.
Well, we're only seeking a mandamus requiring the inspections to happen, not with respect to any aspect of how
They
they're
are
performed.
happening, so I'm trying to push you very hard here about where specifically you would draw the line and how you would defend that.
So
vis-a-vis the law.
I want to take issue with the assertion they're happening, though, because they're not happening. Because what the law requires is proactive inspections universally of everything in the rental registry upon its submission of an application.
So you've just abandoned your substantial compliance argument, has gone to total compliance.
That's what the law requires. There's no compliance, because what the city is actually doing is this is what they say in their reports and their public facing materials, is that they inspect when landlords request it, when tenants request it. That's not proactive, that's
Can I ask
reactive.
you this question? Just looking at the law, does not the law say that for 1 and 2 family rental properties, a landlord must obtain one of these certificates before renting it?
Yes, Your Honor.
Right. Are these properties being rented? Because most of them aren't being inspected, so there's no certificates. Are they being rented out to people with this lead paint poisoning right now?
Yes, Your Honor. And there's also no application for a certificate, so a landlord can't apply for one.
So these landlords, the spirit of the law is landlords can't rent unless they get their property inspected and pass, they get a certificate. Can't rent to anyone for obvious reasons. We don't want kids becoming poisoned here.
Correct, Your Honor.
And that's just going on right and left in the city of Buffalo year after year after year, despite this new law.
Correct, Your Honor. The problem is that the city's they've never established the certificate process. There's no application. Landlords can't apply for them.
Yeah.
All that exists currently is the registry, which always existed.
There's no application. The statute or the statute contemplates some type of application as part of your.
Provides that to obtain a CRP.
They say, their answer is, well, we'll get to it. How long? I mean, an application takes you years and I mean, you can't, I guess it's more of a question for them, but it just seems mind-boggling that we don't have an application by now.
That is particularly mind-boggling, Your Honor, is that the application doesn't even exist. So that whole half of what the Common Council did in 2020 is still a dead letter. It hasn't been implemented at all.
But certificates have been issued.
Yes, when landlords call them and say, I want one, they will issue one, which is not the process provided for by the law.
And the landlords who are probably calling are the ones who take care of their property, the ones where there's lead paint, nobody's calling.
Expect to be issued a certificate, I think. Yes, Your Honor.
I mean, it just seems like you have a unanimous Common Council voting for this. You have the mayor of the city of Buffalo supporting it, and very, very little on the ground is being done to protect these children.
They did fewer than 300 inspections in one entire year, Your Honor, and the law contemplates at least the 12,000 that would get you on the triennial schedule.
Okay.
It's nowhere near substantial compliance. And our position also is that doing reactive inspections that are no different from the code enforcement they always did. If the commissioner is exercising discretion to decide which properties that have applied.
This is the problem. It seems like based on the record, there's 2 inspectors who.
They may have more now, but yes, at the time of the last report, yes, Your Honor.
In our record, as far as I know,
Yes,
they
Your
have
Honor.
they have a supervisor. The 2 inspectors are inspecting not just for these, they're inspecting everything. And it takes roughly about an hour to do one of these lead paint inspections. You got to it is, and they say, we can't possibly do all that. I agree with 2 people.
And what the Court of Appeals said in Klosterman and National Resources Defense Council and in Jiggets is that the fact that it would cost more, that they would have to spend money to
It
comply.
wouldn't be that much more. They say $2.1 million, I believe.
Is not a defense. Yes, Your Honor.
Well, in the city budget, we'll give them $2.1 million. I mean, this is not like we're talking about billions of dollars here. it doesn't seem like, this seems like aspirational only. Here's the law that we want to happen, but we're not giving you enough money to do it. I don't really blame the commissioner because he doesn't have the staff. She doesn't have the staff. But I don't know if this is a political problem or a legal problem or both. But there's no follow through with funding on this bill to get it done.
Yes, Your Honor, which, as the Court of Appeals has said, if there's a mandatory duty, the fact that they would have to come up with the money is not a defense to a mandamus. They can be ordered to do it, and then they have to either come up with the money or change the law.
Anything further?
I suppose on the mandamus, if the court has no further questions as to that aspect of the case, I can move on to the Green Amendment.
Yeah, there's a case out of the third department that went the other way on whether it's self-executing. You saw that, I'm sure.
I did just recently. It was published. I think it was dated a few days before our reply was filed, but I didn't see it in Lexis until afterwards, unfortunately. I don't know that it did. I read that case. It has a paragraph discussing self-execution that I think is very wrong-headed because it doesn't mention the presumption of self-execution, which the Court of Appeals has made clear there is a presumption. The constitutional amendments are self-executing, so I don't think that analysis of self-execution was correct. At the end of the discussion, though, it's not clear to me that the court held that the Green Amendment is not self-executing because they did go on to then cite Chan as to the scope of what the Green Amendment covers.
The third part, it just seems it's so broad. People have a right to clean air and clean water. So, I mean, we could write anything into that. You're saying the courts give us a blank check to do whatever we want. Like you could have any project could be stopped. Anyone could be sued for anything. Here, you could sue the city of Buffalo, right, for lead paint poisoning under the Green Amendment, under your theory, and get monetary damage from the city of Buffalo under your theory.
I don't think so, Your Honor. You need causation of environmental harm. I'm not sure under the case that Your Honor is describing that I know what the action is of the city that caused the lead paint exposure. There's a separate question of whether a damages remedy would be recognized. Which
somebody could sue and say, we don't think there should be gas-powered automobiles in the city of Buffalo. And
so that's very much like the Chan case.
You're violating the Green Act, and then we could agree, no more gas-powered cars in the city. Justice Greenwood has a point.
I was just going to point, if you talk about apartments, okay, so you have gas appliances, and this is a big issue now. So, and all of a sudden you have these doctors come out and say, if you're asthmatic or especially a young child, that's a real environmental danger. So if we agree with you, wouldn't we be creating this horrendous situation for all these apartments and there's supposedly a housing crisis? That they would all have to pull out their gas appliances.
Well, there's two separate,
not just lawnmowers. We're not, right?
I'm not sure why the city would have to, I'm not sure what exactly the claim is, but it would depend on how the court analyzes the claim. So there's two separate issues. Self-execution, there's a presumption of self-execution. We addressed this extensively in our brief. There's no language in the amendment that rebuts the presumption explicitly or implicitly. The legislative history is actually pretty strongly in favor of not rebutting the presumption. The public discourse all assumed this would be self-executing. Almost every legislator who spoke about it thought it was enforceable in court. There's this entirely separate question of what does it protect? And we believe our case is in the core of what pretty much every court, including the Norlight case from the third department, is recognized as protected, which is even the Chan case, which the Norlight case the court followed, held it self-executing. It was just a question of what does it protect? And in that case, and in Norlight, the courts held that it protected a bare minimum level of protection that encompasses New Yorkers' right to have existing environmentally protective laws enforced. And we think we're within that because the PRI law was motivated by a purpose to protect tenants from exposure to airborne pollutants. So this is within the universe of what Chan and Norlight, and I think there's also Streeter held something along those lines.
That interpretation seems reasonable. It's limited to the existing protections people already have. You're not giving us licenses to just make up new ones. I don't
want to imply that I'm advocating that. It's this entire scope of it, but I don't think the court needs to go beyond that for this case.
Right, because once you say airborne, that could be anything. And isn't it better to let the legislature make those determinations very specific, like when it's smoking, obviously a carcinogen, right? And multifamily, it flows through the walls. There's no question of that, right?
Your Honor, I don't think the legislature has the authority to do that. The people ratified this amendment with this language. The language is in plain English language that people use in their everyday lives. It has a meaning. The same argument would apply to educated and this.
You mean the legislature doesn't have the authority to what would you specifically?
So I don't think the legislature can amend the Constitution by statute. There would have to be a
right, they can't amend, right, but they could Just like in Constitution or statute, they can write regulations that they're specifically referring to, can't they?
They could, under the authority of the amendment, they could provide
Right,
specific protections.
Right, sure.
I don't think they could
We have-
narrow the scope of what
In the campaign for fiscal equity, it was a basic sound education, pretty general too, and that was the courts enforced that. So we understand your
Correct.
point
It
on
was the
that.
term educated. The dissent in that case felt that the court would be stepping on the legislative function if it interpreted educated. The majority rejected that. The majority found all sorts of substantive requirements flowed from the word educated, which is just as broad as clean and helpful, Your Honor.
All right. Thank you very much.
Thank you, Your Honors.
Good afternoon, Your Honors. David Lee for the City of Buffalo. I think Justice Curran really hit the nail on the head when he drew the distinction between a government entity that does not a total failure to actually perform a duty versus the governmental entity that is exercising discretion in performing that duty.
What if they exercise their discretion, say we're going to get to 1% of these a year, and we're going to do some when we can't do them all. There's no mandamus there.
I don't believe so, Your Honor, as long as there is an actual genuine effort on the part of the municipality to perform these inspections. And I think there is here. And what I really want to do, and I think that's borne out in the record, but what I really want to do is I want to talk about my initial point, if I may, Your Honor,
sure,
which is that this total abdication of duty versus you're actually performing the duty, just there have been delays. This is recognized in 2 Court of Appeals cases. So we have the one case that involves the New York City Sanitation Department. And there's a recycling program that's mandated by a local law, yet there's a total failure on the part of the New York City Sanitation Department to perform any acts in furtherance of this recycling program. There, the Court of Appeals grants mandamus. Now, in contrast, we have the Lyons case, which involves the County of Albany and, as the case is, it's lead paint inspections. This is a third department decision, but it is affirmed by the Court of Appeals.
Yeah, I was looking at Lyons. It's 52 years ago. And this is the frustration that the plaintiffs have. 52 years ago, the third department says, they said, we recognize the tremendous problem of lead paint poisoning and the terrible threat to the well-being of young children. We must nevertheless dismiss the petition. It's improper, all that. 52 years ago, the tremendous problem. And here we are, 52 years later, kids are still being poisoned. Next to nothing is being done. Very few of these properties. Landlords are renting these properties right and left in the city of Buffalo, despite this new law. 52 years, nothing's being done, and that's why they're here.
I think, though, Your Honor, what I would say in response to that is that the city is trying to be part of the solution here. The city didn't.
So did the city create an application?
The
CRC, did they comply with that?
There is no application, but my understanding, and this would be extra record material at this point, because there was no application when this appeal, or when I should say, I suppose, when the Supreme Court petition was filed. There certainly will be a CRC application. I can't sit here and represent.
What does it take to create one? I mean, why? Well, you talk about partial compliance. I don't know. That one just doesn't seem to make any sense that we wouldn't have an application.
Well, I think in part, Your Honor, it might be because there is this ongoing litigation right now. And I mean, to do something in the middle of litigation that could potentially be used against you, I can sit here, I can represent to the court.
Help the children not be poisoned. But let me ask you this. Let me ask you this. Could not the law be enforced? The law, to the extent it states that a landlord cannot be running these 1 or 2 family rental homes without a certificate. It seems like that's being violated. Cannot at least that be enforced? Like, unless you have a certificate, you can't rent it out. And if you do, we're going to take proceedings against you. Why can't that part of it be enforced?
Well, and the city has to be, they have to know, I suppose, then that there is a rental property being rented to tenants that doesn't have an inspection, and the city is.
Well, they know what houses they've inspected, and they could easily, I don't know, it just doesn't seem like there is the will to follow through with this piece of legislation, financially or otherwise. It doesn't seem like that way to me as an observer just reading this record.
And I can say, and I can represent to the court, and this would be extra record material again, but there is absolutely a commitment on the part of the city to enforce the PRI law. It's really just a question of finding the resources to do it. And the city didn't even have to sort of interject itself into this problem, which everyone agrees is a problem. The city wants to be part of the solution. That's why the ordinance was passed. That's why there has been an effort on the part of the city to perform these inspections. There has been an allocation of resources issue, and that's exactly where the discretion lies. And if you get back to the standard of what mandamus is all about, is there discretion in the performance of this duty? And that's where the allocation of resources, I think, comes in. And the city is absolutely exercising its discretion, doing its best to perform these inspections, recognizing that delays will occur. And I would point to the language in Lyons itself, Justice Lindley, and I'm going to paraphrase here, but mandamus is not available to compel a general, ongoing course of official conduct, particularly when conduct requires administrative discretion, especially in public health enforcement. Now, that's exactly what we have here, I would say. I recognize the case is old, but it is a Court of Appeals case. And I think that the court could easily dismiss this petition and just rely on Lyons. I don't think that Lyons can be distinguished. And
yeah, I wasn't suggesting Lyons isn't applicable. I was just pointing out that 52 years ago, the courts, everyone knows that this problem is significant, and no court wants to step in and do anything, and the problem continues.
And the city's trying to be a part of that solution. The city is absolutely trying to be a part of that solution.
All right.
And I just maybe very quickly on the Green Amendment claim. The city's position is that the amendment absolutely is not self-executing. And if this court were to rule otherwise, it basically presents three scenarios, and none of which are desirable. It's either going to create open-ended liability or governmental entities. Whenever a plaintiff decides that or believes that his or her environmental rights have been violated. Or secondly, it's going to require this court to sort of fill in the blanks that the legislature should fill in. And respectfully, that's not the proper role of the judiciary. Those definitions, those criteria, they have to be filled in by either the legislative or executive branches of government. And just third, it really just gives, I think, potential plaintiffs too much leeway to sort of fill in what the environmental harms are themselves by defining those just to fit the specific needs of their case. And that's not, I wouldn't say appropriate either. It needs to be done by the legislature or the executive branch.
Right. Thank you very much.
Thank you, judges.
Case number 376 is Batty versus Village of Youngstown. Good afternoon. Thank you for your patience. Been a long docket.
May it please the court. Brendan Fitzpatrick, counsel for the appellant. Good afternoon, Your Honors. Your Honors, in its core, this is essentially a prior written notice case. There's no debate that Youngstown did not have prior written notice. That shifted the burden to plaintiff. Therefore, plaintiff had to come forward with evidence of something that Youngstown did that immediately created the condition. Now, last year, late last year, in the Gerbanova against City of Ithaca case, the Court of Appeals again addressed this issue. And according to the Court of Appeals, the burden on plaintiff is to prove that a defect or hazard must have been created by an affirmative act of negligence that, in quotes, immediately results in the existence of a dangerous condition.
This happened over years, and you're saying it doesn't, even though it may have been foreseeable that they didn't re-pour this slab of sidewalk, they just used the old one. And somebody was saying at the time, that's going to settle, it's going to create a problem. You're saying even though it may have been foreseeable, the defect wasn't created immediately, and therefore it's not a creation case.
Yes. Mr. Mueller testified he saw it that day. It was level. He testified numerous times. It was level. There was no tripping hazard.
It doesn't seem like the greatest rule ever. It's like, this is going to be a danger later on down the road. You're going to do it anyways. But because the danger is not immediate, we're not going to have liability. That doesn't sound right.
Well,
I mean, it's probably right legally, but I don't know. It doesn't, the fairness of that escapes me.
Well, legally, that is correct. It has to occur that day. But factually, Your Honor, here we have Mr. Mueller testifying that they had done this before. this doesn't happen. He testified without debate. You could pour a new slab or you could reuse a perfectly fine slab that
I
had
don't
been.
know if that day is though, that's a little, there's cases that are a few days in it, but you're talking 2 years, it's a stronger argument.
That is the stronger argument, Your Honor. What I believe the second department in the Wald case was 10 weeks after. So again, there has to be more immediacy.
Right, immediacy is the key.
And that's what we don't have here. But again, Mr. Mueller testified really without debate that you could pour a new slab or you could use reuse the slab that had been poured, I believe 10 months earlier, that there was no damage to it. And you can't predict whether one's going to settle or one's not going to settle. And Mr. Batty, he testified his concern was it might settle. He didn't say it was going to, because you can't predict something that is essentially up to environmental.
His affidavit's a little clearer though.
His affidavit completely contradicts everything he testified to at his deposition. So at his deposition, he was asked on numerous occasions, what was your conversation with Mr. Mueller that day? Because he spoke with him the day the work was completed, as well as soon after. And he said he was happy that they fixed the sewer because that's where his kids were going to move in at 560 Lockhart. And he said, well, that was it. He goes, I was concerned that the reuse of the slab might settle. He didn't say it was going to. He didn't say, no, you should have poured it again. He just said, I think it might settle. Now, as we all live in the Northeast, sidewalk slabs, they do settle, they do move. There's a tree close by to where this work was done. The tree roots could have moved it. Something that occurs over time.
And nothing stopped them from giving written notice once the plaintiff's family saw that it had settled, right?
And that was
could have given written notice. And
again,
we understand that. And
that was 2 years.
Talk about trivial defect before you sit down at all. You want to get to that?
Just quickly, the Court of Appeals in Trinseri and Hutchinson basically said a condition like this, which is essentially open and obvious, there's not a jagged edge, nothing prevented plaintiff from seeing it, nothing, it wasn't at night, there weren't pedestrians nearby. I think the Court of Appeals in Hutchinson's identified whether something obscures plaintiff's vision of it, whether it constitute a trap or a snare. Here we don't. Even the pictures taken by plaintiff, it's a straight edge.
It's different than trivial defect, though. It's kind of hard to find a trivial defect case in the fourth department.
It is, Your Honor.
I don't think there really is one.
They're more prevalent downstate. I will concede that.
And I would say 1 inch, I don't think we've ever said a 1 inch differential height is trivial. We've had smaller, but 1 inch, you're asking a lot there.
1 inch, I believe we've cited to numerous cases, again, not from this department,
Right.
from numerous other departments where they have found,
Right.
especially under the conditions and the factors that the Court of Appeals set out in Trinseri and Hutchinson, they would consider it a visual defect.
All right. Thank you very much.
I'm sorry, just
Please.
briefly, I just wanted to comment on the opposition by plaintiff. Specifically in the Martin case Martin against City that plaintiff testified to, or that plaintiff cited to, the first department in that case actually said that an eventual emergence of a dangerous condition as a result of wear and tear or environmental factors doesn't constitute an affirmative act of negligence. And that's exactly what we have here. At page 11, they said we didn't produce photographs of the repair. I believe there's significant photographs of the repair. And the only real concern Mr. Batty had before this incident was getting the sewer line repaired, because that's where his kids were going to move in. There are numerous pictures in the record of that work being performed. And additionally, page 386 of the record, Mr. Batty said he went out the same day the work was done and he took photos. No photos from March of 2020, even April of 2020, June of 2020, May of 2020. Nothing show a 1 inch height differential or tripping hazard at this case. It confirms with Mr. Mueller's testimony that he testified this was level, was flat, there was no tripping hazard at the time of the work was performed. Page 12, again, they say the reuse of the unbroken slab violated a safety code. I don't believe that's the case, but even if you can see that, again, that's not immediate creation of a defect, which that is the law in the state of New York. Page 13, they said the defective condition existed because they used the old slab. Again, that's that temporal ipso facto argument. There's no evidence to actually support it. And finally, I believe that we've identified numerous points where Mr. Batty's affidavit, where he says it was misaligned that day, it was misleveled that day, and I complained to Mr. Muller. He never testified to that. He was given numerous occasions, at least 3 occasions during his testimony. Say, what was your conversations like with Mr. Muller after the work was performed? He said, I was happy.
He told him the day the work was complete.
Yes.
So wouldn't those things, all those things you just referred to, wouldn't they be questions of fact?
No, Your Honor, because he said that in his affidavit. In his testimony, he said, I was happy they fixed the sewer. His only concern was it might settle. He never testified that it was misleveled at the time. And there's no evidence whatsoever to contradict Mr. Muller's testimony that it was level and there was no tripping hazard at the time of the accident. Unless there are any further questions, I'd ask the court to reverse and dismiss the complaint.
Thank you so much.
Thanks for your time.
Good afternoon, and may it please the court, Thomas Lyons from Duke Holzman here on behalf of the plaintiff respondent, Tina Batty. If your honors would humor me for a second, I'm just going to start in reverse order and respond to a couple of the points there. First, and most notably, the appellant takes a significant portion of their brief and argument here today to take shots at Mr. Batty's affidavit and suggest that it was flatly contradictory and therefore the trial court should have utterly disregarded it and taken their testimony as unrefuted. However, I do want to draw the court's attention to a few things. Number one, record page 32 and 33 is the decision from Judge Giacobbe. Judge Giacobbe cited not just to the affidavit, but also to the deposition testimony itself, where he, and I quote, told in his decision that Mr. Batty testified, as Judge Ogden pointed out, that the same day that the work was completed, March 16th of 2020, Mr. Batty notified Todd Muller, the Department of Public Works supervisor for the village, that it was done wrong, done in violation of the town codes and standards, and was going to pose a danger to pedestrians in the village. I'm not sure that there is an affirmative requirement.
He had a background in construction, so it wasn't as always just opining on things that he's not qualified to talk about.
And respectfully, Judge, I would disagree that whether or not he can be qualified as an expert, but on the motion, I agree. There was no stamp of him being an expert, but he was an eyewitness. He did own the property next door.
What I'm saying is that wasn't, I mean, he knew whereof he spoke.
Correct, Judge. Yes. He knew exactly what he was referring to and identifying this to Todd Muller, that this was a defective condition that existed that day. He also, by the way, page 616 in the record, followed it up in writing to Mr. Muller the same day, notifying him of the same thing, that, hey, you're doing the work. I want you to make sure that there are photographs of this work because I'd like it for my file. And then has a contemporaneous handwritten notation on the top of that printed out email confirming the phone call conversation he had with Mr. Muller that same day. Page 616 in the record. So to be clear, there was a complaint. Did he physically say the words in that conversation? I think it's raised by an inch. That's a question of fact. The affidavit says that he observed it that day. And to be clear, trial counsel for the appellant here did not ask the question. There are 113 pages of sworn testimony from record page 354 to 467. And the question to the effect of Mr. Batty on March 16, 2020, after the village completed its work, did you observe the condition your wife was in or not? That question does not appear anywhere in that transcript. And I submit to you, I have been doing depositions a long, long time. I have instructed every witness in the world that I have defended, answer the question that's asked, not the one they don't ask. Mr. Batty did exactly that. Mr. Batty told the deposing attorney what the answer to the question he asked was. And I'll also point, Your Honor, to the point that on page 384 of the record, not only did Mr. Batty actually follow the instructions of not answering something that wasn't asked, he was actually cut off in the middle of multiple mid-answer narratives to counsel and told, I don't want to keep you here all day. Let's get back to my actual question. Fair enough. That's the consequences of conducting the deposition the way it was. You didn't fill in all the holes and the affidavit did. By the way, in that same vein, I would expect that if we are making an argument that the deponent absolutely contradicts his testimony so clearly that it would warrant disposing of it entirely on a summary judgment motion, that there would be an actual direct quoting of the contradictory testimony. There's not. There's the paraphrasing and mischaracterizing of it throughout the briefs and over a course of 17 pages of it, but there are no direct quotes saying, he said this, he then said this. These two things do not align. Judge Giacobbe actually in his decision I very clearly articulated on page 32 of the record how those two things are not directly contradictory. They may be slightly inconsistent at best, but that is exactly the reason why it is something to be tested at trial. And that is why we are here asking that this court simply affirm the lower court's decision. Judge Jacoby got it right. He didn't wade into the province of the jury. He said, these are issues. The jury's role is explicitly to decide credibility issues.
Thank you very much.
Thank you, Judge. If I may, one thing on the triviality.
You may.
Judge, you pointed out the triviality, and I agree with you. We cited multiple cases, including Morris, Amos, and Trinsier from both the Fourth Department, 2022 in Morris, 2020 in Amos, and the Court of Appeals, 1997 in Trinsier. There is no bright line that an inch is a trivial.
Depends on what if it's in the road, it's different than if it's on the sidewalk. It depends, it's all the circumstances. So, and you would say it's up to the jury to consider all that. Thank you very much.
Thank you.
Case number 378 is a matter of Todd D. Carville versus Honorable Burnett T. Clark. Case 378. Mr. Labella, good morning, good afternoon. Ms. Schwartz is here with us virtually. You may proceed.
Thank you, Your Honor, and good afternoon, and may it please the court. Michael Labella on behalf of petitioner. The proceeding before the court today is about fairness and contradiction. The Supreme Court, in its decision, had gone through and, in the beginning, informed petitioner that they had no obstacles to represent this case to the grand jury. However, in the later decision, the court, when after sealing the record, had then stated to the people that you were violating the sealing order by presenting such materials to a grand jury proceeding.
Right. It seems like the dispute here is, in your view, the court sealed evidence. And the statute, CPL 160.50, does not talk about sealing evidence. It talks about sealing records. You think the judge misinterpreted the statute, interpreted too broadly? Because you would agree that there's a sealing order in effect. You're not challenging that in this proceeding, right?
Correct.
You didn't challenge it on February 4th when you could have back in the day. February 4th of last year, there was no objection to the sealing order, right?
Correct. We did not object.
And you didn't appeal from the June 12th order that denied the motion to unseal from the sheriff's office. So you're not here today talking about sealing or unsealing. Do I have you right?
Correct. I'm not here today for that.
You're here to talk about what does sealing mean? What records does that encompass? You believe that Judge Clark went beyond just mere records. Records, usually the ones in the statute, fingerprints, booking photographs, whatever. She went beyond that and precluded evidence that is beyond the scope of 160.50. That's the heart of your contention. Is that right?
Yes, but also on a separate matter, I'm also contending that the presenting material or such records to a grand jury proceeding, which is entirely secretive and not public in any way, would not go against the sealing statute. And also in that it's the same type of, it's a criminal consequence, not a non-criminal consequence in a separate
Could you
proceeding.
say that again? Did you say, if you use records that are sealed in a grand jury, that's not a problem? Is that what you're saying?
I'm submitting that, yes. And
all right. I thought, that's a tougher one. I thought you were saying evidence that is not within the scope is being submitted to the grand jury, but I think Justice Del Conte has a question.
Just to clarify procedurally here, as I understand it, your objection, the reason this is special proceedings before us is you believe the court went too far in prohibiting you from going to the grand jury.
Prohibiting us.
So it basically enjoined you from proceeding to the grand jury. That's your position.
Yes.
Not what evidence you could present. That's a separate issue. You have a separate appeal pending on that issue.
Yes. However, I'm also noting and submitting to this court that the use of such materials, the Supreme Court had also stated that we were to cease and desist from using such materials and stating that we were violating the order.
Right, but that it was a repeat of, for lack of a better word, of the February 4th order. There's no additional sealing in this particular order. This order talked about preventing you from taking steps. Your position is those are steps that we're lawfully entitled to proceed with as the county prosecutor.
Yes,
Yeah.
that we were still entitled to use such records in the pure exception, in the pure limiting scope of a grand jury.
So you're saying you want to use records that are sealed by law, you want to use them in the grand jury? That's what you're saying right now?
Yes.
Okay. Where does Judge Clark in the order say you can't present it to another grand jury? I thought she was explicit that you can. She can't stop you from doing that. We said you could represent, you could move for leave. Where does she say you can't represent to the grand jury?
Between the paragraph stating that we had violated it by using the materials in the grand jury proceeding and then informing us to cease and desist from the use, those read together.
Well, you could use other evidence that's not sealed, right? She's not saying that.
That's correct.
Yeah,
our concern,
I tend to agree with the argument that had been made that CPL 16050 is quite limited in what gets sealed. Very limited. We're talking about records. The idea of the statute is to prevent stigma to the defendant who's been exonerated. Stigma is not a problem here for this defendant. Okay. Everybody knows she sat down for a Netflix documentary. This is not about evidence isn't sealed here. You could go to the grand jury and present evidence as long as it's not those limited records that are being sealed. But you're coming here today saying we want to use records that do fall within the ambit of 16050, and that's more problematic. You're saying you want to roll it, you want to use evidence that's supposed to be sealed, and you're going to take your chances with the validity of the indictment later.
Yes, but also with regards to the scope, we have been concerned of the scope currently used with the sealed materials would not lead us to enough to provide a sufficient indictment.
Right. Well, not if the sealing. The problem is this. Judge Clark went through all the evidence that's been presented to the grand jury, did she not?
Yes.
And went through and said, this is sealed and this isn't, item by item, I assume?
She did not.
Oh, she didn't?
No.
She just said you're using, because we don't have any of that evidence. So I don't have any idea. I suspect that sealing, that this order is too broad, that she's sealing evidence that is not covered by 160, but how do I know? Because I don't know what the evidence is. And the overriding problem, Ms. Schwartz talks about this, is that you're complaining about, you're saying she acted in excess of her jurisdiction in the June 12th, 2025 order.
Yes.
From which the county did not appeal. Right? The county could have appealed. The sheriff's office was aggrieved. You were brought in, you had notice, you arguably could have filed an appeal. Why no appeal of the order that is causing you all these problems?
Which order is your honor?
I'm talking about the June 12th, 2025 order.
We could not. We were not a party to that. It was not our motion.
That's debatable because you were brought in, but why there was an aggrieved party called the Oneida County Sheriff's Department. No appeal. And now the way they look at it is that you're trying to collaterally attack. The time to file an appeal is gone, and now you're bringing a writ when you could have had all these issues presented to us on direct appeal. You meaning law enforcement agency, the sheriffs. I think arguably you could have as a DA because you were brought in and you had notice, just like Ms. Schwartz had notice. But that's what there's questions of should somebody have appealed that June 12th order, and is a writ of prohibition the right way for you to get relief?
I would argue yes, and that is the case here. That this was our only option because even though we were brought in, we would have only been seen as an interested party. We could not have been seen as a party. We did not bring the motion.
Could you have asked the county attorney's office to appeal? Because they represent the sheriffs.
I'm unaware if our office had that conversation.
Well, see, part of the problem is you got in trouble according to the judges. You asked them to bring the application in the first place, and now you don't ask them. I mean, you might as well just go on and ask them to do everything once you've gone down that road. But yeah, so is a writ of prohibition. We would have to say, to grant your writ, that the court acted outside in excess of her jurisdiction, the judge. And we don't know because I don't know what evidence she believes is sealed and what evidence she's precluding you from submitting to the grand jury. We have no idea. Part of the record with the transcript, it's all redacted. I suspect she's explaining her ruling there, but I don't know what her ruling was. So it's hard for us to say whether she got it right or wrong based on what we have now, which you've given us.
Okay. The last thing I would still note with regards to the motion itself is that given it was an ex parte as statutorily defined, there is no avenue to appeal and direct appeal and ex parte inaction of an ex parte motion, in that the only avenue from there is a separate Article 78 itself, which we had brought this as a way of that, given that we didn't have standing to try and bring the.
Now, you do have an appeal from the February order, correct?
Correct.
Right.
You, is the sheriff's office about a subsequent motion to unseal? There's no time limit in the statute, or you're just riding on this writ?
They have not brought a separate unsealing motion. Certainly not to my knowledge. From what I have seen, they have not. They have only.
And no other law enforcement agencies, sheriffs, I'm sorry, the state police, nobody else has done it?
No, given that it was the sheriff's office that was the law enforcement agency to the case. And also there were a lot of issues in regards to that the defense had noted, or respondent had noted in their answer, stating that the sheriff's office had a lot of issues at the first motion. So it would seem that they're not willing.
I understand the frustration of your office. This woman was convicted of a homicide. There is abundance of evidence that she poisoned this woman, and the woman died as a result. When I wasn't on the case, but we reversed it, it was not based on lack of evidence. It was based on a mistake by the attorney. The only reason this is before us is because the indictment had to be dismissed because the top count the defendant was acquitted of. If she was convicted, and then she was convicted of manslaughter as a lesser. If that was charged in the indictment, we wouldn't have dismissed anything. It would just go back and you make a suppression motion. So it's an odd situation, but I get the frustration that you want to present this to the grand jury, and you're being hamstrung. But some would say, as a result of not asking for it to be unsealed on February 4th, consenting to that order, not appealing from the June 12th order, various other steps. So I don't know where this leaves you, but any last words you want to say before we turn it over to Ms. Schwartz?
Your Honor, I just wanted to note for the court that what we're seeking is either from this court asserting a clarity of this court's authorization to allow us to represent the case, and also to allow us to still provide using such records for the limited use of a grand jury proceeding. I find it very distinguishable to say that it would not violate a sealing order to present such records to a secretive grand jury proceeding that is simply presented to an investigative body and not any type of public agency or private agency. And with that, I would rest. Thank you.
Thank you. Ms. Schwartz.
Good afternoon. May it please the court, Melissa Schwartz on behalf of respondent Caitlin Conley. I think the panel's confusion on what the petitioner is arguing is well-founded, and that's because the petitioner is not asking this court to review the scope of the sealing order. That is not in their initial brief. They only brought it up in their reply brief. And if you look at their initial brief, what they're asking the court to review is exactly what Justice Del Conte pointed out, and whether or not the Justice Clark exceeded her jurisdiction in saying, hey, you violated my sealing order, stop presenting sealed material. They're not asking this court to get to that ultimate issue, which I'm not going to litigate here because I don't think it's appropriate, and the people do have an appeal pending litigating potentially the scope of that issue if it's preserved for the court's review. So I don't believe that this court can then opine on the scope of the order. Right,
they did argue it below, but they've touched upon it on appeal. And I know you would rely on matter of Dondi and everything, but as you say, we don't need to get into that because for the simple reason that we have no knowledge of what evidence Judge Clark reviewed. So we can't even if it were before us, we can't decide whether her view of what's sealed comports with our view. So it's just, the record is just insufficient for that at all. So now it sounds like what he's saying is we want to use sealed records to the grand jury, even though they're undisputably sealed. That seems to be where we are right now.
Correct. And that was my initial problem that had this entire hornet's nest kind of come to be, right? Is that I've learned that they had presented all of the evidence in the case besides voting it, and it was my interpretation of 16050 that the matter was sealed. Just in terms of the procedural issues, and this is kind of something that has been bothering me, is the people's argument that they were not an aggrieved party and that this was an ex parte order. The nature of an ex parte order would be that one party that didn't have an opportunity to be heard. In this case, the people had ample opportunity to be heard. They actually were heard more so than anybody else in this case. And I suspect why the county attorney's office hasn't appealed is because there was some, outlier circumstances with their filings, right? And ended up getting their filings precluded because they were not being ethical in what they wrote to the court. So I assume
they use AI for a
correct.
Memo of law, but in your view, the DA could have appealed, just like you could have appealed.
Absolutely. They submitted a memorandum of law that was accepted by the court. They provided oral argument. They were given an opportunity to cross-examine the lieutenant, and they were actually given an opportunity to reply to my argument. They had every opportunity to be heard. This wasn't ex parte. And they're also making a contradictory argument that they're not aggrieved, that they're just interested. Well, if you're not aggrieved by the order, then why are we here? You can't have it both ways. And I cite to Hoffler from the third department on that argument. But I don't think this court can decide the issues that the people want this court to decide to allow the case to move forward.
Well, couldn't we decide the issue of they want to use records that are sealed? Sounds like Judge Clark is just saying, follow the law here. You can't use, that seems to be what she said. That doesn't appear to be outside her scope of her jurisdiction. Couldn't we rule on that one?
No, because it's not outside the scope of her jurisdiction.
But I mean, couldn't we say it's not outside the scope? She's just saying, don't follow the law is what she's saying.
Again, I think this goes back to one of your initial questions or your initial comments was that we don't know what that is. There was obviously a ruling regarding that. I was not privy to it. I was not part of that conversation. I waived the ability to go in because it pertained to the grand jury proceedings and those are secret. But no, I don't think this court can rule. I frankly don't think this court can rule on any of the issues that the people have asked this court to rule upon.
Or alternatively, the relief isn't available in this civil proceeding.
Correct.
They just can't get what they're asking for.
Correct. Unless the court has any other questions for me, I'll rely on my brief.
Thank you.
Thank you.